Hello everyone, good evening, bonne soirée à tous et bienvenue à cette rencontre du Comité de dérogation pour la Ville d'Ottawa. Welcome everyone to this meeting of the Committee of Adjustment for the City of Ottawa. The Committee of Adjustment, as many of you probably already know, is a quasi-judicial tribunal that's appointed by City Council to make decisions on certain types of planning applications, the most common of which are consents and minor variances. And tonight we also have a permission that we're going to be dealing with. My name is Anne Tremblay, and I'll be your chair for this evening, but I have with me also this evening our full panel. We have Mr. Colin White, we have Ms. Kathleen Willis, Ms. Julia Markovich, and we have Mr. Scott Hindle, who I know is here this evening. He's maybe just a little late in joining us, but he will be here. I'd also like to acknowledge that we have a terrific committee staff that supports us for all of these meetings. So we have with us this evening the Deputy Secretary Treasurer, Mr. Matthew Garnett. We have three coordinators, Ms. Emily Byers, Ms. Mandy Nguyen, and Ms. Maddie Harriman Fernandez. So thanks to all of you for assisting us this evening. And Mr. Hindle, thank you for, I was just mentioning your name, so good entrance. Please take note that this session is being video conferenced. If you want to get a copy of either the agenda or this video in the coming days, months, weeks, you can do so just by going to the city's webpage under the Committee of Adjustment, and you'll be able to find those materials. If you have any issues, please don't hesitate to reach out to our committee staff. They can help you with that. So before we get going, there's always a few instructions that we have to provide just to lend some context to the way that this committee operates. So first of all, we all recognize that there's a lot of issues when it comes to development anywhere in the city. But the Committee of Adjustment is only mandated to deal with a very narrow set of issues. So to be honest, it's really only what is before us. So whatever is in the application is all that we really can deal with. And so if there are issues that are relating to items that are outside of the variances that are specific to the application, those are really things that we can't do anything about because they're deemed to be in compliance with the zoning bylaw for which minor variances aren't required. And on that basis, we don't get to make decisions about those kinds of things. We also don't really discuss noise, pollution, property maintenance, impacts on property values. We don't consider any discussion regarding prosecution from illegal construction because we deal with everything as if no development has occurred. We also will ask you to be mindful of your neighbors and the applicant and the owners, and just be respectful. So we won't entertain any adverse comments about anybody who is involved and participating in these dealings. And finally, if we find that there is during discussion the need for an additional minor variance, or greater relief from the zoning bylaw, in those cases, we need to adjourn that item and we need to make the changes to the notice and recirculate. So we would get that item back onto the agenda as soon as we can, in terms of as a later date. So as part of the statutory public notification requirements, each applicant is required to post a sign on their property and then file with us a statutory declaration that essentially says that that sign has been erected and that it was there for the amount of time that's required under regulation under the Planning Act. So that declaration, typically when we were doing this in person, we would get these declarations in person, we would get them hard copies. But now what we're doing is it's great when we get them in advance. If we don't, we can always use a verbal solemn oath or affirmation. And so that's what I will be administering to applicants and agents and owners as we move through this. With respect to quorum, if we lose, we have to lose 3 out of the 5. If we lose that many, then we do have to step down the remaining items on the agenda to another meeting. We'll of course try to reestablish the quorum so that we don't have to do that. But that's essentially the way that we'd have to proceed if that happened for whatever reason. So in the hearing process, so let's talk about that. You saw at the beginning that we had a rather full agenda for this evening, a lot of items. And typically what we try and do is go through the agenda in the order that they're shown. And it really is only based on how the applications came in, no more than that. At times, we may actually find that we want more fulsome discussion on some of the items, and those we're going to just leave to the end. And for those, we're going to require presentations. So for the most part, we've adopted a fast track system where we do become very familiar with all of the materials on the file before we get here this evening. So in those cases, we may ask some questions just for clarification to see whether or not we've fully understood the material that we've read. So in that case, the committee members will ask questions of the agent or the owner, and from that point then we'll essentially provide an opportunity for the public to speak. In some cases, I have a public speakers list where I'll start with that. But if not, then we can open it up to anybody who has an interest in the application. We may ask people who speak to the committee or want to address the committee further questions for clarification. And then after all that is done, and we get the answers that we're looking for, the committee can then make an oral decision. So typically we grant applications, we can refuse applications. We can also adjourn an application if during discussion we realize that we really do need, as I said, to bring it to a later meeting. Or we can reserve on an application if we feel that there's been a lot of new evidence provided to us as part of the public portion of the presentation. And in those cases, we will then we will close the hearing, the public hearing, but still make a decision on the application before we essentially adjourn for the whole evening. So we will then reconvene just to discuss those applications that would be reserved, and then we make decisions. So on the decisions, once all of that happens, there is formal decisions that are prepared and then are issued within 10 days of the hearing. And that will include our reasoning on why an application was granted or refused. And those decisions are appealable to the Ontario Land Tribunal for a fee within 20 days. So there's a 20-day appeal period for which you can do that if you're not in agreement with the decision by the committee. So that's it for our opening remarks. I just want to make the one comment that that Member Willis is with us this evening. Member Willis will at times be off screen, as she is right now, because for her own reasons, but she is listening, and you will see Ms. Willis come forward when she's involved in discussions and questions to the owner applicant or to a speaker, and so no worries. She is completely engaged in the hearing as it unrolls or as it proceeds. Okay, so we've got at this point a couple of items of business. So I need from the members somebody to move a motion to adopt the minutes of February 2nd. Do I have a mover? Mr. Hindle, thank you. Do I have a seconder? Mr. White, thank you very much. So the minutes of February 2nd are adopted. I also have the minutes of February 16th. Do I have a mover? Ms. Markovich, seconded by Mr. Hindle. So we now have approval of our minutes for February 16th. So that's great. Beyond that, we can move to our adjournment requests. I think that's what we'll deal with. We don't have too many this evening, which has not been our typical sort of circumstances in the last several meetings, but we do have two for sure, and then we're going to call another one just to be sure we understand. So on 767 Pleasant Road, I'm looking for Mr. Ahmad El Khatib. Good evening.
Good evening, everyone.
So, Mr. El Khatib, you are aware that there is a request by planning staff for an adjournment on your application. Is that correct?
I'm not sure about the journey. Like,
You're not aware. You did not. You did not contact the planning staff. You didn't get a copy of their report on your application, or did you?
they asked for some more paper. I emailed it today.
All right, so we're going to, Ms. Cully, I'm going to ask you to come forward if you can, please, because it seems to, according to the notes that we have, there's quite a bit of information that you'd still been asked and Mr. El Khatib to provide to you. Did you receive that information?
Through you, Madam Chair, I did not receive that information. I did have a meeting with an individual who I understand is working as an agent on behalf of him. And we had a conversation about what needed to be changed and the adjustments that need to be made to the application materials. So I understood those would be provided, but I have not received those.
Yeah, just today, we provided today. Sorry for the delay.
Yeah, well, so we can't deal with materials that come in the day of the hearing. So staff has to have a chance to look at it. They have to have a chance to provide a professional opinion to us. They have to have a chance to add it to their report. So we can't hear your application this evening. We simply don't have. In all fairness to staff, we have to give staff the time to be able to review that information and to come back with us with a more fulsome overview of the material that's been provided. So with that, then I think we're proposing an adjournment sine die on this application. So, and do you understand what that means, Mr. El Khatib?
Yes, yes.
All right. So before we go there, though, I do want to give the public a chance to come forward. Is there anyone in the audience who wants to speak to this adjournment request, either for or against? All right, I'm not seeing anybody come forward. So committee members, all those in favor of an adjournment sine die?
I appreciate it.
All right. So for the record, that decision is unanimous. So thank you very much. And we'll see you back when staff has had a chance to receive all of the material and to have reviewed it.
You know when will be the next?
I have no idea. You're going to have to speak with committee staff tomorrow morning.
Okay, I appreciate it. Thank you.
All right, thank you very much. Okay, on to the next, which is 11 Tower Road. I believe I'm looking for Mr. Segreto.
Good evening, Madam Chair.
Good evening, Mr. Segreto. I understand that you have made the request for this adjournment.
I have, I need 2 more weeks to resolve some of the issues that we have with the trees. We are going back and forth with the planning people, the tree planting people. So we just need a couple of more weeks to tweak a few things and I'll have it done by then.
All right. Just to our Deputy Secretary Treasurer, Mr. Garnett, what would the date be? That would be April. I didn't look it up, but is that April 7th?
I believe it's April 6th, Madam Chair.
April 6th. All right. So Mr. Segreto, does that work for you?
That's good. That's very good. Thank you.
All right. Any questions for Mr. Segreto on this from anybody? No? All right. Is there anyone in the audience who would like to speak either for or against this adjournment request? Ms. Wilson, do you want to speak to the adjournment? Ms. Wilson, come on forward. Ms. Wilson, did you want
Can you hear me now, Madam Chair?
Yes, now we can hear you.
We just wanted to say that we have been in touch with Mr. Segreto and we agree with the adjournment. So it's all good with us, the Community Association.
All right, excellent. We love to hear that. Perfect.
Thanks.
Anyone else in the audience want to come forward on the adjournment to April 6th? All right, I'm not seeing anybody else. So panel members, all those in favor of the adjournment to April 6th, show of hands, please. All right, for the record, that decision is unanimous. So Mr. Segreto, we'll see you back in another 3 weeks on this. As you know, it's a longer month. All right, thank you so much. All right. There is another one that I'd like to have a chat about before we go too much further. And that is for 34 and 36 Gretton. And I think we're looking for Ms. Leah Bauer. That is our planner. So I'd like Ms. Leah Bauer to come forward. And the agent on file, who would be Ms. Charlene Zandbelt and Mr. Tucker, well, from Tucker Design, I think is Ms. Zandbelt. All right. Do we have that agent with us?
Hi there.
Hi there. Okay. So just, I was looking at some of the comments from the staff report. And what we're wondering is whether or not staff actually has all of the information that they need in order to be able to really be able to warrant to us that there's no further minor variances required to this for us to hear this application. So notably what we've heard is that there's information about the soft landscaping that's been requested.
Yes.
And some verification as to how the building height was determined.
Okay, so yes, I apologize. I just sent that back yesterday. And I have included the soft landscaping calculation in the site plan, and we are well within our maximum of 40%. And the calculation for grade was taken as per the description with the City of Ottawa.
All right, so Ms. Bauer, are you in receipt of all that information?
Thank you, Madam Chair. Yes, I am in receipt of that.
All right, so are you then okay with proceeding with this application? You don't see any need for any further minor variances?
Yes, I am okay with proceeding.
All right, in that case, Ms. Zandbelt, we'll see you a little bit later. We just wanted to have that discussion, make sure we had what we needed before we went too far. Okay. All right, thank you. I'm putting you back in the lineup.
Okay.
So, all right, so that is it, folks, for our adjournments. So we are going to go straight to number 1 at this point, which is for 619 Manor Avenue. I'm looking for Mr. Ritzy.
Good evening.
Good evening, Mr. Ritzy. Did you want to put your camera on?
Yes.
All right, because I do have to do the oath with you verbally, so it does help to be able to see you. All right, so do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted first at the property to which the application applies, that it was there for the prescribed number of days prior to the hearing, and that it was clearly visible and legible for the entirety of that time? Do you either affirm or swear that to be true?
I affirm that that's true.
Okay, so you're okay, very good. So with that, then, no presentation required. This is fairly straightforward. So I'm going to open it up directly to questions from the members of the panel. Anybody have any questions for Mr. Ritzy? See, that's straightforward. That's straightforward. So, okay.
Well, it's been a long process.
Okay. Well, I don't have anybody on my list of speakers for this item, so I'm just going to make a call. If there's anyone in the audience who has an interest in this application and would like to speak either for or against. It's item number 1, 619 Manor Avenue. All right, I'm not seeing anybody come forward. So with that, I think we're ready for a vote, unless members of the panel have any questions. No. Ready for the vote. All right. All those in favor of the application? All right. For the record, the application is unanimously granted. So that is, I think that's all we need with you, Mr. Ritzy. So you're approved.
Okay. Thank you very much.
All right. Thank you so much. All right. We're going on to number 2, which is 301 and 303 Terry Fox Drive, looking for Ms. Emma Clark.
Good evening.
Good evening.
Hi, sorry for the delay.
No worries. It takes a little time. It takes a little time for everyone. So, okay, I'm just going to need to read to you first. So do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted first at the property to which the application applies, secondly, that it was there for the prescribed amount of time prior to the hearing, and lastly, that the sign was visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
Yes, I affirm that to be true.
Perfect. Just another little housekeeping matter with you. My understanding is just a very small change to the legal description is required. We are striking part 14 and replacing it with part 13.
That's correct, yes.
All right. I just wanted to do that, make sure that that was on the record. Okay. No presentation required from you, Ms. Clark, this evening. Opening it up directly to the committee for questions. Anybody have any questions about this application for consent? Nope. All right. So let's, and I don't believe I have anybody on my speakers list. I don't. So I'm going to make a call out to the public. Is there anyone in the audience who has an interest in this application, 301 and 303 Terry Fox Drive? It's a consent application. Now's your chance if you want to speak either for or against. Okay. I'm not seeing anybody come forward. So with that, and I'm not seeing any questions from the panel members. So all those in favor? All right. For the record, the application is unanimously granted. So thank you, Ms. Clark, for your time.
Thank you.
Thank you. All right. We're going on to number 3 and 4, which is for Pine Glen Crescent. So 4 Pine Glen Crescent. Looking for the agent on this, which is Ms. Pagliarello. Sorry, I'm going to get Pagliarello. Do we have the agent or somebody who's coming forward? Good evening.
Good evening, Madam Chair. Apologies for that. It's Philip Osterhout. I'm the lawyer for Mr. Trapani.
All right, I'm going to need to take your name completely. So it's Philip. And sorry, your last name is Osterhout?
That's correct.
Okay. And can you just for the record, because you're not on my list, I do not believe. Ah, yes, you are. Actually, you're a second agent named. Okay, good. I'm glad to have that. Excellent. Okay. So on this, I don't think I have a declaration, so I'm going to have to read to you. If you just bear with me.
Yes, Madam Chair, and my client has actually joined us now, and he's able to take that.
All right. So can you please introduce your client? So who are we talking? We're talking about Mr. Sorry.
This is Mr. Giuseppe Trapani.
Okay.
Madam Chair, I was on the application as the agent for the application and added Mr. Philip Osterhout.
Okay, because I don't see your name on anything that I've got. So sorry, can you just give me your family name again, please?
My family name is Trapani, Trapani.
Okay. All right. And you are an agent. You're acting as an agent for this?
I am.
Who then is Viella Francesca Pagliarello? Who would that be?
My sister.
Ah, okay. So you're here on behalf of your sister. Is that correct?
Yeah, she had never done this before, and she asked me to do it for her.
All right. Can we have your municipal address, please, Mr. Trapani?
342 Booth Street.
Booth Street. Okay. That's here in Ottawa.
It is correct. Ottawa, Ontario. K1R 7K3.
All right. Thank you very much. That's perfect. We do need to have that for the record when we have people appearing that aren't on our list. So, okay. All right. In that case, I need to read to you. Do you solemnly swear or affirm that the notice provided to you as part of the application and by the committee was posted on the property to which the application applies, that it was there for the entirety of the prescribed amount of time prior to the hearing, and that it was clearly visible and legible the entirety of that time? Do you either swear or affirm that to be true?
True.
You swear or you affirm? Sorry.
I
Do you swear, you affirm? Okay, thank you. I just didn't quite hear you there. Didn't quite catch what you said.
That's okay.
All right, so in this case, I do need to make, I believe, a housekeeping change on your application. So in the zoning, the notice recognizes that it's a residential first density subzone E with bracket R1E unbracket. And then it had the exception, I believe, 1722, but we're going to strike that because my understanding is that doesn't apply. Correct?
That's correct, Madam Chair.
All right, perfect. I believe that takes us to the end of our little admin things here that we have to take care of. Okay, so we're not going to request a presentation from you, but I believe this application has a number of elements to it that panel members may have questions about. So I'm going to open it up to the panel at this point. Questions? Yes, Ms. Willis, go ahead, please.
I have a question, I think, for staff, and I think it's Ms. Ramirez. Yeah. Just about procedures here, and I see that I'm just trying to understand the hydrogeological comment. Is Ms. Ramirez there?
Yeah, just give her a minute to come forward. Okay, thank you.
Hi.
Good evening, Ms. Ramirez.
Good evening.
So am I understanding this correctly, that a suitable hydrogeological study was not submitted to support the reduction in lot size, notwithstanding that it's a very minor reduction in size, but I think it's the ground conditions that require more rigorous study, and the study was not completed, and the hydrogeologist is of the opinion that notwithstanding that, I'm not saying this very well, the incompletion of the study, that the lot is just going to be too small for technical reasons to support this development. Is that sort of right?
Thank you for the question, Madam Chair. That is correct, that no study was, septic impact assessment was not done in support of this application, and the opinion of the hydrogeologist is that the lots are simply too small to be able to accommodate two septic systems.
So just following up with that question, the fact that we have a variance, we see that because of that, the staff feels that the variance is not minor because it, in the opinion of the hydrogeologist, will not support the effluent. If there had not been a requirement for a variance, how would this have been caught simply as a consent application? Would it have been at building permit stage a requirement that a study be done and then that study would fail? Or is there no mechanism for a requirement when it meets the minimum zoning standards if there's no variance application included?
Thank you for the question. It would have been caught at the consent application stage because in support of the consent application, that study would have needed to come forward. So if there was no minor variance application associated with this consent application, we still would have expressed concerns because there was no study submitted to accompany the consent application, and the lots are too small.
But if I'm just trying to understand this, if it turned out that the applicant had submitted one and was able to convince technical staff that the lot was of sufficient size, that's a lot of ifs, but let's say that did happen, then it could possibly be a recommendation to support the application if it was based on technical evidence.
We always recommend that applicants pre-consult, especially when there is private services. And at that stage, I would have brought in the hydrogeologist, and at that stage, they would have expressed concern that there could not have been a study that would have satisfied our requirements.
Thank you.
All right, any other questions? Mr. White, go ahead, please.
Thank you, Madam Chair. Yeah, I'm concerned that in the absence of the study, that perhaps we're being a little too anxious to turn this one off. The zoning bylaw is pretty clear that it permits the lot sizes to be reduced, provided that there is information that shows that the reduction in the lot area is not adverse impact upon, and quite frankly, the bylaw itself doesn't talk about water quality in the aquifer. It really only talks about the ability of the septic system that's installed to accommodate the increased water capacity that's provided by the fact that the unit's connected to municipal water. It doesn't say anything with respect to water quality in the zoning bylaw. I'm just thinking that, I mean, if we're being asked to turn this application down in the absence of a study that might indicate that otherwise might be appropriate. I've also noticed that I did refer to, in looking at this one, I did refer to the MOE guidelines that were discussed in the planning report. And those guidelines are pretty specific in that they apply to developments of 5 or more units. In this case, we're not dealing with 5 or more units, we're dealing with 1. I know in the past that, in fact, there's a lot, if we refer to the area plan that was attached to the notice, there's a lot immediately across the street at 1 Briggs and 3 Pine Glen, which is essentially an identical, essentially a very identical sized lot that was severed sometime in the past on the basis of lot size that is, I would suggest, somewhat similar to what we're being asked to deal with here. And that one was approved on the basis of a septic system, as is being proposed in this case. So something's changed here. I would suggest that I don't believe that we're in a position to necessarily approve an application tonight, but I think that in the absence of the study that's required, that we really shouldn't be dealing with the application until such time as that's available.
All right, thank you, Mr. White. Ms. Ramirez, can you give us a little bit of the history with regards to those other lots that appear to be in the range of the size that would result from a consent of these of this property? Can you tell us a little bit about that?
I am not sure that a septic impact assessment was done in all of the cases for those consent applications. I know that from talking with staff who are more knowledgeable about this than I am, they expressed a high level of doubt that the lots are large enough. And the zoning bylaw does include a statement that says, despite what the minimums that are identified, larger lots may be required to account for those impacts for the septic systems.
Okay. I believe that's also, that theme is also present in the OP, right, in terms of the policies?
The official plan speaks to needing to have no impact on the groundwater quality, the existing OP, and the new official plan strictly prohibits lot creation on private services or partial services where the lot is not 0.4 hectares or 400 square meters within the urban area.
Okay. So I guess the question that bears exploring, and what Mr. White has raised, is whether or not a study is going to, so is it worth it to have a study done, or do we already have enough information now to determine that we likely wouldn't be in a position to demonstrate feasibility of development without impact on the adjacent properties? I guess that's the question. Any thoughts from any other members? Mr. Hindle.
Yeah, I was curious, and thank you, Ms. Ramirez, for your outlining of especially the zoning and the 2 OPs in their policies. It sounds, in my reading of especially the new OP, it doesn't seem like there is as much flexibility as there was in the 2003 OP that the new OP says 0.4 hectares, right? Is there wording similar to what's in the 2003 OP that allows a site-specific study to potentially alter those requirements, or is it fairly set in stone based on your reading?
Thank you for the question, Madam Chair. It's fairly set in stone. Those additional requirements are, those studies are needed to accompany lot creation when it's being requested for private services. And I will note that there are still the language that you can have in an area where there are partial services you can develop as long as the lots are 0.4 hectares in the urban area. Okay,
so in this specific iteration, in this location, given that interpretation of the OP that the requirement is 0.4 hectares, and there's not really language that would support varying or reducing potentially that minimum standard, is it your understanding then that short of the lot getting bigger and meeting that 0.4 hectares, that conformity with the OP for an application like this would basically be impossible to find?
Thank you for the question. Yes, that is correct.
Okay.
All right. Thank you, Ms. Ramirez. Mr. White, you have a follow-on question?
Yes, Madam Chair. Appreciate what's being said in the official plan. However, we do have a zoning bylaw that is fairly clear that allows for the reduction in lot area to, 1390 square meters, or sorry, 930 square meters in the event that it is proven out that the septic system is capacity and ability to accommodate the new development is adequate to ensure that it's safely done. I think we need to deal with that because we're being asked to vary the zoning bylaw provision by only 1 square meter. And
well, so yeah, but Mr. White,
in order to do that, study.
The only thing that, when I read what the staff has offered with regards to zoning bylaw, it says 930 square meters, and it's very clear that, it may require larger lot sizes necessary to meet, essentially to accommodate the servicing system. So I don't think it's fair to say that we're only varying by a meter when in actual fact, the measure of what we're really varying it by is what's required in order to, so if, for example, the servicing studies identified that even smaller lots could be developed, then yes, then we're only dealing with the 1 meter. But the reality is that study determines what the minimum lot size really should be, notwithstanding what the zoning bylaw says. At least that's my read of it. And so if that's the case, so for me, it still goes back to the question of, would it make any difference if a study was done? But I think I'm hearing not so much because there's too many other impediments to it, and we've got an opinion. So I'm just trying to figure out at this point: do we move forward with a direction that requires that this come back with the study and the comments, technical comments from staff, or do we deal with the application based on what's in front of us today? Ms. Willis.
Just a suggestion. I don't know whether or not this was put to the applicant. It sounds like what we're hearing is what you've just interpreted, that doesn't matter what the technical study says, because the official plan says that there'll be nothing less than 0.4 of a hectare. So I suppose we could put it back to the applicant to determine whether or not they want to adjourn the application and attempt to convince the city that it's appropriate, or have them agree that we deal with the application tonight.
Well, and I agree. I think that's a wise way to proceed. But I really do want to know why. So there's pre-consultation normally that happens as a regard, in advance of applications coming before. So Mr. Chapin, can you tell us why then? Why wasn't the study done? Did you not pre-consult with the city? Were you not aware that some of these technical issues needed to be squarely addressed?
Originally, the lots across the street and to my north were severed with a minor variance. And when I spoke to the city, nobody asked me to do any kind of anything else other than what I've applied with.
Okay,
So
so
if they
who
were,
did you talk with? Can you tell me who you spoke with at the city so that we know where you, because typically it's directly with the planning staff and they will do a pre-consultation meeting with you. So who did you speak with?
so the only person I spoke with at the city was Paul Connor.
Okay.
And anything he asked me to provide, I provided, and nothing was asked for a study. Had it been asked, I would have done it.
Okay, but does the application, so I'm looking to the
Madam Chair, I wonder, I might be able to provide some assistance here.
So just let me find this out, because I'm curious. I just need an answer to this. Because it seems to me that there's all kinds of signals to go to pre-consultation. So, and it doesn't sound like any of that really happened here, other than just the submission of an application. So Mr. Garnett, can you just come forward for a minute? Just remind me, what's on the application for minor variance? Does it include a pre-consultation requirement on it? I just can't recall.
There's, Madam Chair, direction in the application in terms of a list of people or groups that might be pre-consulted with. There is also sort of proviso information about additional requirements that planning staff may have. But Paul Connor is a member of committee staff in terms of identifying minor variance application requirements. It would just be the plans and forms that we require in all cases.
I thought. All right. Thanks for that. I appreciate it. All right. So Mr. Oster, over to you.
Thank you, Madam Chair. And I appreciate that this may have been a helpful case for pre-consultation. That being said, as you indicated, some of the lots in the neighborhood have been severed by consent, specifically the one across the street, 1 Pine Glen and 3 Briggs. I have those backwards, 3 Pine Glen and 1 Briggs, I believe were severed in 2012. And so I understand from what Mr. Trapani said, that may have been a reason why it wasn't pursued. With respect to the requirement for the plan, the current official plan does speak to severances of lots that are on partial or private services, specifically with respect to wastewater and water. And particularly policy 4.4.2.2 of the official plan, which deals with the review of development applications for severances, includes a provision that the city will grant provisional consent subject to a condition that servicing study of sufficient detail to establish evidence of site suitability undertaken prior to a certificate of consent being issued. And so I think what the zoning bylaw is contemplating by saying, as you indicated, a minimum lot area of 930 square meters, but as may be necessary, this provision is expanding on that and saying a consent may be granted subject to conditions, and specifically contemplates that the study be done. And if it can't be satisfied, the consent will lapse.
All right. Thank you, Mr. Osterhout. That's a good explanation. Ms. Ramirez, go ahead, please.
I guess I would say that the Committee of Adjustment can impose any conditions that it deems to be appropriate, but we shouldn't be imposing conditions that we know the applicant will not be able to meet. And all the direction that I've gotten is that the applicant will not be able to meet the study requirements, that the lots are simply too small.
All right, thank you. And you did say earlier that, to your knowledge, you don't think that study requirement was imposed in the creation of the lots that surround the subject property that we're talking about.
I do remember that this is similar to an application that was heard a couple of years ago, and I did do some research into the area and the consent applications that happened there. And I do know that at one point, a septic impact assessment was requested, but the committee didn't impose that condition.
In 2012.
In an earlier severance, I can't recall the exact date.
All right. Okay, and that happens. Things change. And, the regulations change as well. So I'm back to exactly the same question I had before, but Mr. White, go ahead, please.
Thank you, Madam Chair. I do recall, I was involved in some of these severances previously, believe it or not. At the time of a lot of these consents that happened in Pine Glen and also in Grenfell Glen, there were a few in that area, which is a similar partially serviced area or unserviced area. The conditions that were required with respect to septic system approvals were handled directly with the Ministry of Environment. The applicant was required to, and I think Mr. Osterhout is correct, the applicant, the conditions were applied requiring the applicant to go to the Ministry of Environment and obtain approval of the septic system, period. It appears that there must have been some change to that process. And I'm not sure if it changed between 2012 and now, but certainly before that time, that was the process. The Ministry of Environment was the approval authority with respect to, essentially the approval authority with respect to reducing the lot size for these things based on the adequacy of the sanitary sewage system. I'm not sure, maybe perhaps staff can advise if that process has obviously changed, I guess.
Ms. Ramirez, do you know anything about any changes that the Ministry of Environment might have imposed between 2012 and today? That's a tall order to ask, Mr. White, so just to say.
I'm not aware. I don't have an answer to your question. I can take it back to staff, but I don't have that answer.
All right. I'm going to propose a compromise here. So I'm not prepared to approve this and condition it. And I have some, I think there is some merit if the applicant is willing to go and do the study and be able to demonstrate to planning staff and our engineering staff that in fact there's feasibility of development on these lots, which means we'd be looking at an adjournment. So I would like to get some feedback from the members of the panel as to an adjournment. I'm going to give it at least the next 5 weeks. So I'm going to say into the second meeting in April to see whether or not we can't get that study completed and then reviewed. Mr. White, go ahead, please.
Great, Madam Chair. I wonder if we could just ask the applicant what their thoughts are on the preparation of a study of that nature prior to us dealing with the application.
Absolutely. Go ahead. Who wants to answer that question?
Let Philip answer it.
I think my client is prepared to prepare the study in either event, and obviously we're agreeable to that being a condition of the approval. Certainly our preference is to proceed with the application as soon as possible, but if we're looking at an adjournment to April to accommodate that, I think that would be reasonable.
I'm trying to find a compromise here, Mr. Osterhout, because I'm not prepared to approve anything without, based on all of what we've heard. It's been pretty sort of, fairly negative in terms of any hope of really meeting the requirement, but I'm willing to say, give it a shot if that's what you want to do and come back to us. So I guess the question becomes, is mid-April enough time? Because now you have to go out and you have to get the study done. I see Ms. Willis and her experience is saying that ain't going to do it. So
just if I may, I was going to ask a question first, and then I was going to address that. And my question to Ms. Ramirez is whether or not there is any master plan on the horizon that you're aware of that will extend sanitary sewers to this area, which will then lead to the possibility of greater intensification in time.
Madam Chair, thank you for the question. I am not aware of any plans to extend services to this area, so that intensification could occur.
Okay, so knowing that, I think that any of these studies that I've been involved in the past take a very long time to do. So not to dissuade, I just think April 6th is not nearly enough time. It can take a very long time to engage the engineer, do the terms of reference, do the study, get it into the city, get it approved. It's a lengthy process. So I would say April is not a realistic target.
all right, in which case we have a fair number of people who want to speak to this application. I'm almost tempted to Propose an adjournment sine die, recirculation, and come back.
That makes sense from my perspective, Madam Chair.
All right. Okay. Then I think that's what we're going to do. So we're moving towards a sine die adjournment. So I do have a number of people who want, oh, Ms. Ramirez, before I go to the public, or did you want to speak?
Yeah, I just, thank you, Madam Chair. I just wanted to raise that a study the official plan is quite clear in that 0.4 hectares is required for lot creation on partial services. So I just wanted to raise that I can understand the desire to want to compromise, but the new official plan is quite clear on what is required for lot creation on private services.
And the new official plan is in full force and effect?
No, Madam Chair.
Wait, Mr. Osterhus, please give staff the chance to answer. Thank you. Go ahead, Ms. Ramirez.
Thank you, Madam Chair. The direction we've been given is that until the ministerial approval of our official plan, the city is to apply the policies that are more restrictive. And in this case, the new official plan is more restrictive.
Okay, all right, but I think the committee has a little more latitude on that. So, okay, was that your point, Mr. Wright?
Yes, thank you, Madam Chair. Yes, I mean, the call on terms of compliance with the general purpose intent of the official plan is ours to make at the time of the decision. The time that
and that's fine, and that's fine. That's why I'm
problem with the adjournment sine die, the study coming in, being analyzed by staff or the Ministry of Environment or whoever the approval authority is, and us dealing with it at that time. That's the risk of the applicant that the applicant takes.
All right, excellent. In which case, any other questions before I go out to the public on this? All right, so I do have a number of people who want to speak. So Mr. Kelly, I see you're there. I'm going to ask you to come forward. At this point, we're not dealing with the application. We're dealing with the question of adjournment sine die. Did you want to speak to that? Mr. Kelly.
Good evening. Can you hear me?
Yes, we can hear you.
Okay. No, we don't. I don't have any objection to that. To adjourn for today and come back to it when the study is completed.
All right. Okay. All right. So I just want to make sure I go through my list and touch base with others that have put their names forward. So do we have Mr. David and Genevieve McCormack? All right. Hello, Mr. McCormack. How are you?
No objection whatsoever to your proposal. Thank you very much.
All right. Thank you so much. And the last person that I have is Ms. Agnes Warda. I know you're here. I saw your name earlier. So on the adjournment?
I don't really have a problem. I only wanted to mention before we go on the adjournment that the consent approval, which was given originally, was not 2012, it was 2001 and 2003. And there were issues with the lot being that small, and the current occupant, it's having issues with the septic slightly failing. So if it fails, there will be a major issue for that person because the lot is very small and there is no place to go. I just wanted to correct the statement that there is no problem. I have no problem with adjournment and looking forward to whatever will happen.
All right, thank you very much. Is there anyone else in the audience who would like to speak to this request for adjournment sine die? All right, I'm not seeing anybody else come forward. So with that, panel members, all those in favor? All right, so for the record, the decision is unanimous. We are adjourning this application sine die. So good luck then with your study and with coming back to us with the information that we need.
Thank you, Madam Chair.
Thank you.
All right, thank you. Okay, on to number 5. We're looking for 6330 Renault. Mr. Eric Thériault, please. Mr. Theriault?
Yes, good morning, Madam Chair. Good morning, committee members. Thanks for having me.
So, Mr. Theriault, I don't know what part of the world you're in, but we're in the evening. So,
Oh, I said good morning?
you did say good morning. You did say good morning, but that's all right. So it's just a nice greeting anyway. So I think I need to read to you before we deal with your application, however. So do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies, that it was there for the prescribed number of days prior to the hearing, and that it was clearly visible and legible for the entirety of that time? You either swear or affirm that to be true.
I affirm, for sure.
Thank you very much. That's perfect. Okay. No presentation required from you. This is quite straightforward. The committee has had a chat about this before the hearing. So I'm going to open it up. Mr. White, you have questions? Good. Okay, go ahead, please.
Thank you, Madam Chair. Just a quick one. I just want to know that staff is, it's not indicated in the report, but staff is obviously satisfied that the proposal doesn't compromise the objectives of the development reserve zone here, which is to deal with future development, future planning and development of the lands. And I'm assuming that they're satisfied that it doesn't compromise that work.
Go ahead, Mr. Ramirez.
Thank you, Madam Chair. Yes, staff is satisfied.
All right. Thank you very much. Any other questions, Mr. White? All right. Okay. Then with that, no questions from anybody else. And I don't have anybody on my list to speak. So is there anyone in the audience who would like to speak either for or against this request for permission at 6330 Renault Road? All right, I'm not seeing anybody come forward. So panel members, all those in favor? All right, for the record, your application is unanimously granted. Thank you, Mr. Theriault.
Thank you very much. Thank you.
Okay, great. We're on to number 6 at this point. And that is for 34 Granton or 36 Granton. So yeah, I think okay. All right, this is the one that I called down earlier, I see. Yes, Ms. Thank you. So I need to read to you, Ms. Zandeveld, right?
Yeah.
Do you solemnly swear or affirm that the notice provided to you as part of the application process by the committee was posted at the property to which the application applies, that it was there for the prescribed number of days prior to the hearing, and that it was legible and visible for the entirety of that time? Do you either swear or affirm that to be true?
I swear that to be true.
Perfect. Okay. I don't believe we're asking for a presentation on this one. Just need to see whether or not there's housekeeping. There's no housekeeping. Okay. All right. So questions from the committee. Mr. White, is your hand up from before or is it new? Then go ahead, please.
Madam Chair, I assume we're going to be hearing from the City View Community Association, but just a question about the planning report. There's reference to the planning report to the neighborhood transitioning towards a denser lot fabric. Post 2011 intensification in this area has only required minor variance applications for lot width and lot area because of historical ownership. I'm just wondering what happened in 2011 to change the circumstances.
The question is to who, Mr.
Sorry, that would be to staff.
All right, Ms. Bauer. So I think, so Ms. Bauer, if you want to, okay, come forward. Okay, go ahead.
Thank you, Madam Chair, for the question. I would like to defer that question to Ms. Ramirez.
Thank you, Madam Chair. That's when there started to be those minor variance applications for lot width and lot area only to permit development. Staff reviewed our electronic files, and that's really where the break started, where lots in the area to intensify only required those minor variance applications.
Further questions, Mr. White?
Can I ask how did it work before that? Before 2007? There were some severances and creation that occurred for that time.
So before that time, what seemed to happen is that lots would sever off a portion of their lots in order to form a new lot and to do a lot, basically a lot addition, so a new lot would form. And generally the lot width sizes before that time were about 19 meters.
Okay.
Thank
So
you.
the standard increased over time.
The lot width being promoted by the city staff was reduced. I understand that.
I can't say I've looked at all the reports to know what that's if staff was supportive of all of them, but the Committee of Adjustment decisions were to approve those lot width and lot area minor variances.
All right, any other questions from the members of the panel on this? All right. Okay, I'm going to go to our public then in my list on item 6 and number 7, 34 and 36 Granton. I have the City View Community Association. I've got Ms. Jill Pratt and Ms. Nancy Wilson. So Ms. Wilson, I see that you're here. Did you want to go first?
Sure. I'll be the only one going tonight because Jill's at another meeting. We tag team these meetings on Wednesday nights. So good evening, Madam Chair and committee. I'm not going to read to you about the part about the new OP again, because we've talked about that before, how we think that things should be held until our secondary plans are in place. With respect to this application, the only concern that the City View Community Association has identified is the request for reduced frontages and lot areas. The developer didn't reach out to us as a community association. And one of the things that we noticed on the planner's report, and I'd just like to welcome the new planner, Leah. I spoke to her today and it was a pleasure speaking to her, is that the house is waiting to be taken down and it hasn't come down yet. Can you hear me okay?
Yes, we can. We can hear.
So I'm getting this sort of echo. So I just wanted to make that point that the house has already come down. The house has been taken away last fall. So the four tests, the City View Community Association still maintains that the requested variances to facilitate the development of this, and I'm speaking as one because we did a separate one for 34 and 36, but it's the two of them together that I'll be referring to. Variances to facilitate the development of these detached dwellings on oversized lots does not meet the general intent and purpose of the zoning bylaw. The official plans policies encourage infill and intensification, but the provisions of the zoning bylaw R1FF 632, which reflect greater limits on the character of the residential infill, have not been updated to reflect the same intent. These variances are not minor in our opinion. On this block of Granton, there are 14 houses. 8 of those properties are 100-foot frontage and lot areas of approximately 880 meters squared. 4 of those lots are between 65 and 79 foot and meet the bylaw requirements. And I guess those are the ones that we're talking about from before 2011, because they met the bylaw requirement and by buying off a section of the property beside them. And 2 have 60-foot frontages with lot areas of 500 meters squared. Those 2 60-foot frontages, I'm not 100% sure because I wasn't there, but I think from looking at it, one of them is there was 2 lots. One was a 79-foot lot, and now there's 2 60-foot lots beside it. And I think those are from splitting up 2 lots. So 79 foot sold off 20 feet. And then they had to split it. And the reason it was 79 feet is because of where the house was located that they kept. The proposed development is not in keeping with the dominant character of the street and therefore does not maintain the general intent and purpose of the official plan. Further, the requested variances do not maintain the general intent and purpose of the zoning bylaw because this proposal does not represent orderly development that is compatible with the surrounding area. It's unfortunate that other parts of Granton that are 3 blocks away, which were once affordable family bungalows, have been changed dramatically and permanently due to these massive infills on severed small lots. This is an example of why the community objects to these developments outside of our existing bylaw. Although precedents are not allowed to be considered, these huge infills have I can't say the word tonight, changed the character of our neighborhood. Perfectly solid, affordable homes have now been torn down for the benefit of the developers' profits. About the trees, I'm not going to read the infrastructure things to you because we already know the problems we have with City View's storm sewers and the ditches and things. So I've already sent that in to you, and I've already sent in about the cash and lieu. So we won't read anything about the cash and lieu, except that the cash and lieu will not be getting funds from this house. But the tree, we'd just like to say that a beautiful large sugar maple was taken down and other trees have been pre-cleared before this application was put in. The sugar maple, they'll tell us that there was a permit for that, but the forester that was dealing with this property said that he would not have given that permit to cut down that silver maple. There was nothing wrong with it. But when he was on holidays, they went in, spoke to the new forester that was taking over for him, and he signed off on the permit. So that's what happened to the beautiful big sugar maple. And of deep concern at 34 Granton is we want to make sure that the tree number 2, the majestic silver maple, which belongs to the adjacent property at 32 Granton, as well as tree number 1 in the front of the property, the Crimson Norway at the front of the property, are carefully protected during this build. At 36 Granton, trees 3 and 4 are marked for removal, yet their condition is listed as good vigor. There should be more of an effort to save these trees. They are on the back corner of what is lot 36 Granton. The eastern hemlock, tree number 3, takes 250 to 300 years to reach maturity and may live to 800 years or long after we're all gone. Do we have the right to kill this tree? Should we build around these trees? And I sent a picture of the property so that you guys could look at it. I'm sure you have. And please note that the areas for a tree canopy in City View are limited compared to many other communities. Because of ditches, trees cannot be planted along the roads on the city property at the front of the houses. Also, above ground power lines and wires reduce the location that trees can be replanted. So the city planner has suggested that they put 4 new trees in to take place for the 2 that were taken down, the 2 protected trees. I can almost guarantee that there's going to be no place to put those 4 new trees. What we're suggesting to the developer, and other developers have done this, is that they can speak to us, the community association, and we can tell them where in the community we need trees, and they can take those trees and put them somewhere. Unless they have a place on their property to put it. If they don't, they can put it somewhere in the community to benefit our community. And that's all that I have to say for tonight. And that's for both 34 and 36. Thank you.
All right, thank you, Ms. Wilson. I do have a question for Ms. Young. Ms. Young, our forester. Good evening.
Good evening.
Just a quick question then. So I'm looking at the additional comments, and you've seen this application. You've provided comments, okay?
Yep.
And so when when there's proposals here that say, for example, that 4 required compensation trees, do you have a chance to look at the properties and to figure out where that could go and how it might work? So I'm just trying to figure out, like, to Ms. Wilson's point, so you're saying there's ditches in the road. It's difficult to, in fact, plant those trees. But in your review, do you have a look at where some of these things could actually be implemented?
Thank you for the question. No, I don't really take into account. I mean, I look at the size of the property and see if there's generally space to plant trees, but the number of required compensation trees is strictly based on the size of the trees that are proposed to be removed. So under the tree protection bylaw, if there's a tree between 30 and 49 centimeters to be removed, 2 new trees need to be replaced. And if it's over 50 centimeters, then 3 new trees need to replace it. So my putting in of the 4 new trees there is just based on that. And as Ms. Wilson noted, there are situations where there is not space on this site to plant, and we are open to trees being planted elsewhere in the community, as long as the tree planting plan submitted by the applicant includes the addresses and permission from those people and approved locations of those trees. So they need to do the legwork to sort out where those trees would be planted, but we are open to accepting that.
Oh, that's excellent news, I think, Ms. Young. I didn't realize that those kinds of solutions could be brokered. So wonderful if that's the case. I am hearing that it needs to go through you, though. Yes. So it's not that it's a deal between the developer and the community associations. It still has to come back to you, even if it's not a condition, because in this case, these are not conditions. So, all right. So, but that's good to know. So thank you so much for that information. I appreciate that. Okay. I'm going to make a call out for anyone else in the audience who might have an interest in this application, either for or against. Now would be your chance to come forward. All right, I'm not seeing anybody else come forward then. Ms. Zandbelt, I guess I have just one quick question for you that was raised by Ms. Wilson. So can you tell me a little bit about the consultation that you undertook on this application? You're on mute. You're on mute.
In what regard?
So in terms of just speaking with the community association and surrounding neighbors, that kind of thing.
Yes, so the owners that I was working with, I was under the impression that they had met with the community association, but I realized very shortly ago that they had not. And I believe that he reached out to them yesterday after we received their letter.
Okay, so that's too late in the game, right? As you know,
yes.
Right? So the idea is to work with neighbors in developing the plans before they even get to us, right? Even before they're submitted, there should be some engagement, particularly with the community associations. In this case, this community association, I can tell you, is very engaged. So they're more than happy to make the time to speak with you. So I would just invite you to ensure that if you do applications in the city again of this nature, just be mindful about consultation with the community associations and with the neighbors. So it's just a principle that we like to just try and foster with our neighbors.
And I'm sure the owners and myself would be happy to deal with the community association with the tree issue and put them where we can to make them in the best location.
Excellent. That's great to hear. Okay, terrific. With that then, if committee members don't have any more, Mr. White, sorry, didn't see that. See, go ahead.
Thank you, Madam Chair. I actually have just a question of the Ms. Wilson, the Community Association. I agree with everything that Ms. Wilson's had to say, with the exception of one item, and that is the comment that although precedents are not allowed to be considered, frankly, that's not correct. Precedents are allowed to be considered, and there's absolutely nothing that precludes us from doing that. We are not necessarily bound by precedents. That's the general rule of thumb, but certainly we are able to consider precedents in our deliberations on these applications. Secondly, I'd just like to ask Ms. Wilson, it sounds like she's familiar with the severance that the lot creation that took place on the adjacent property, 38, 40, and 44 Granton Avenue. And that was the result of the combination of two existing holdings, which were, I think, 100-foot frontage each, resulted with the lot line adjustments that happened, resulted in the establishment of one additional dwelling unit. with the minimum lot size on 2 of the lots being the 60-foot frontage that she mentioned. And then the other 24 meters, whatever that converts to, I think it's 24 meters. That would be close to 665, the bylaw requirement, the bylaw minimum requirement. Recognizing that, I'm just wondering how the community association might feel had we been dealing with this this property in conjunction with 32, which is the lot on the corner, to combine in terms of lot line adjustments, to combine those to introduce a third dwelling unit on those 2 lots. I think what we're going to see, and I'm talking about precedents here, what we're going to see is that if this application proceeds, no doubt we'll see a similar application on lot 32, which in the end will result in 4 dwelling units on those 2 properties, as opposed to the 3 example that we saw on the adjacent property at 38, 40, and 44. I'm just wondering what the community association's feelings might be if that were the scenario, as opposed to what we're dealing with tonight.
I think that I know that lot 32 is not going to sell their lot come hell or high water, but you never know what could happen tomorrow, right? But I think if you took those 2 lots, 32 and 34, and put them together and had 200 feet and divided them up, you could have 3 lots there that are 65 feet that are conforming. So that's what we like to see, and that's what we've always seen. And I think that's what happened down a bit farther, except that I think the house that was saved on the 3rd one over, that's 79 feet left, I think that's because of where the existing house was. And so there's only enough room to make it into 2 60-foot lots, which is 4 feet short of the amount that you need for the bylaw. But we know that lots are getting split into 50-foot lots. So if 32 and 34 were sold and they tried to do 4 lots, that's the way it's going these days. That's intensification. And we've almost come to accept that it's against the bylaw. So that's why we're there every week fighting that, because it is against the bylaw. And what we would say is you've got 200 feet there divided into 3 lots that are 3 conforming lots. And as for precedents, we've asked that question so many times. I mean, the chair can tell you, we always say it's precedents count. And I guess maybe we've got it wrong, but we're always told that precedents doesn't count. But over time, things have gotten to be the way they are. So that's become the character of the neighborhood in those areas. So that's how we understood it. So if we understood it wrong, I'm sorry. Anyway,
Ms. Wilson, to be honest with you, that was my understanding too. So it really is supposed to be on the merits of what's before us for each application. But the context does make a difference. And you're right. So over time, when you have that context, that's what becomes, it's not precedence as such, but it definitely is, it definitely becomes a contributing factor to the decision making.
Yeah.
So Mr. White, I'm going to just let you ask just one last question. I think we might be ready to go to a vote.
Yeah, Madam Chair, I'm not saying that precedent is not a factor. What I'm saying is that we are not bound by precedents. However, there's nothing stopping us from taking it into consideration in our review of these applications.
Yes, granted. I agree. Okay. All right. I don't think there was anybody else that was looking to address the committee. So we've got 2 applications here before us, 2 consent applications. On the first one, 34 Granton Avenue, minor variances. All those in favor? All right. So for the record, we have 4 members that are in support of the application and 1 that is dissenting. Mr. White, did you want to give your reasons for dissent?
Thank you, Madam Chair. My reasons were outlined fairly well by the City View Community Association representative. I'm the opinion that the application is premature in the absence of a comprehensive planning and zoning review that's long overdue in this area. The minor variance, in my view, is not minor and is certainly not consistent with the general purpose and intent of the zoning bylaw as it is currently written. That's my reasons for dissenting.
All right. On the application number 7, which is for 36 Granton minor variances, all those in favor? Okay, so similar vote, 4 in favor with Mr. White dissenting. Can I just say that it's for the same reasons? Is that sufficient? All right, okay, thank you. So for the record, the dissent is for the same reasons Mr. White articulated on the previous application. And with that, then I think Ms. Zandbelt, I think we're done with the 2 applications. Granted. So good luck. All right, thank you. Okay, we're on to number 8 at this point, which is 99 Norris. Looking for Mr. Bingfen Lee. Do we have the agent? Yes, we do. Okay. Can you come forward, Mr. Lee?
Hello?
Hello.
Yes. Can you hear me?
Yes, we can hear you and we can see you. So that's great.
Okay. Good evening, everybody.
Good evening.
Yeah.
So before we get into your application, I do have to read something to you.
Yeah.
So do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted first on the property to which the application applies, that it was there for the prescribed number of days prior to the hearing, and that it was clearly visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
I swear this is true.
All right. Okay, great. I have no housekeeping amendments to undertake on your application. We're not going to ask you for a presentation, so I'm going to open it up to questions directly from the panel members. Anybody have any questions on this application? Really straightforward, I think, on this one. All right, I'm not seeing anybody come forward with questions. So on number 8, I have nobody's registered to speak. So is there anyone in the public who would like to address the committee on this application, either for or against? This is 99 North Street. It's for a minor variance. Now's your chance. All right, I'm not seeing anybody come forward. So with that, panel members, all those in favor? Okay, for the record, the application is unanimously granted. So thank you, Mr. Lee, for your time this evening.
Thank you very much. Thank you, everybody. Have a good evening.
All right, thank you. Okay, we're on to 1225 and 1227 Ridgemont, and I'm looking for Mr. Ibrahimapur. Mr. Ibrahimapur. So to the coordinators, do we know if Mr. Ibrahimapur is here?
Hi, everyone. Do you hear me?
Yes, we do.
Yeah. Okay. Sorry.
So I'm not
Hi,
seeing, the name I'm seeing on screen is Motion.
Yes, that's I'm Majid Ibrahimipur brother. He is on vacation, so I'm covering for him.
All right. I am going to need your full name and address then.
Yeah.
So.
Our address is the same. My first name is Mohsen, M-O-H-S-E-N, and the same last name, Ibrahimipur.
So I was looking for Mr. Ibrahimipur, and I'm getting it anyway.
Yeah.
So that's good. Okay.
Yeah, thank you.
I need to read to you before we go too far.
Yeah.
Do you solemnly swear that or affirm that the notice provided to you as part of the application process and by the as part of the application process and by the committee was posted on the subject property to which the application applies, that it was there for the prescribed number of days prior to the hearing, and that it was clearly visible and legible for the entirety of that time. Do you either swear or affirm that to be true?
I affirm that is true.
Perfect. I also have to note with you that we have a slight amendment to make to the notice.
Yes, I have
So
seen
there-
that.
All right, so I just need you to confirm once I read it out. So the retained land showed as part 1 on said plan will have a frontage of 7.605 meters and not, we're going to strike out 7.065. Is that correct?
That's correct. Yeah.
All right. Okay. With that, we're not going to ask for a presentation on this application. So I'm going to open it up to questions from the committee right away. Any questions on Richmond? Yes, Mr. White.
Thank you, Madam Chair. I believe we have a question concerning the staff report on this one. The request for the additional condition on parking.
Okay, sure. So this is Ms. Cully.
Yeah, and I'm just reasoning behind this, like parking enforcement's normally a job that's carried out by bylaw enforcement officers on a routine basis. I'm just wondering what the necessity is for this additional condition to be added.
Go ahead, Ms. Cully.
Thank you, Madam Chair. This condition was added after the fact, after hearing concerns from residents that on-street parking is occurring despite the fact that it is not allowed on this street. The portion east or west of Edge Hill Place, I can't remember which off the top of my head, but whichever portion is east or west is no on-street parking. So this is a condition that is typically included in subdivision and site plan. So it was recommended that it might be worthwhile to have this notice on title so that if someone is renting or purchasing the property, they're aware that there's no on-street parking in addition to the signs that already exist on the street.
All right, thank you, Ms. Cully.
So is it my understanding then that this is not a uncommon situation to impose such a condition in a subdivision agreement or a site plan agreement for a development? What about building permits for this new development?
Through you, Madam Chair, I understand it is common in subdivision and site plan control, but beyond that, I'm not sure how common it is. That is the notice that is typically provided in those development applications.
Okay, so Ms. Cully, I have a quick question. Did you get the wording for this new condition from legal services themselves? Did they draft this?
Through you, Madam Chair, the original condition is drafted through legal services. It has been amended slightly by the senior planner.
Okay. All right. But generally, it's in keeping with what was the originally drafted by legal services. Okay. All right. I just wanted to make sure that we've done that, and we've already got a condition to enter into a development agreement, correct? Right. Okay. Any other questions from anyone? Ms. Willis, go ahead, please.
Knowing that this is a standard sort of notice, I was originally not very supportive of this, but I'm wondering in this case whether it's appropriate to have the first sentence. You're asking that this go on title. But it's saying that the semi-detached dwelling unit being sold, rented, has only one legal parking space, which could presumably change over time. And similarly, it says there's currently no on-street parking permitted on Ridgemont west of Edge Hill. That too could change. So I'm wondering if the condition and the notice would serve its purpose by removing the first sentence and the last sentence so that it does not just reflect a snapshot in time, and the warning about the availability of parking remains notwithstanding whatever happens on the site itself.
Ms. Cully.
Through you, Madam Chair, I had raised that concern as well, the snapshot in time, if you will, of it being worded in a condition that way. And the senior planner had said that at least with the last sentence, that is something that has been included in site plan and subdivision previously. But that's all I can state beyond that.
All right.
I'd be more comfortable making it more generic by removing the first sentence and the second sentence or the last sentence. And I think it still provides the warning that we think is what's required to stop people from insisting on getting parking spaces on the street.
I agree, Ms. Wallace. I think that's a good, I think those are good modifications, but I do want to hear from the rest of the panel. Can you just quickly tell me if you're in support of that modification to the condition? All right, so yes, I'm seeing that. All right, okay, so we're going to do that. We are going to take that out. So starting with the words, the purchaser, all the way to on site, that comes out in the first sentence. And then we're taking everything starting with, there is currently no on-street parking. That work for you, Ms. Wallace?
Yes.
Okay, we can take that out. And because I agree with you, I think it's not necessary to get the point across. Okay, so with that then, is there anything further, any further questions from the committee on this? All right, I don't have anyone listed on my speakers list, but is there anyone in the audience who would like to come forward and speak either for or against this application at Ridgemont? All right, I'm not seeing anybody come forward. Just a quick question to you, Mr. Ibrahimipour.
Yeah.
You've looked at the conditions, you're in support of the conditions and including the additional one that we have. And Ms. Cully, I think, is it a new condition number 8 or condition number 7? Because I'm seeing in the list of the summary that we already have 7. So is the new one actually condition number 8?
Through you, Madam Chair, the report submitted to committee had 6, so I had indicated it was 7, but the Deputy Secretary Treasurer is coming forward, so that might need to be clarified.
Ah, Mr. Garnett, because maybe it's just the way that the summary was worded.
Excuse me, Madam Chair. I believe there is also a condition in that list from Bell Canada for an easement.
Ah, that's it. Okay. All right, so the staff reports number 7 is the new one, but we still have a condition. So thank you, Mr. Garnett. I probably didn't even let you finish there, but I caught it as soon as you said that. So there's the additional condition by Bell Canada. Okay, very good. And so, Mr. Ibrahimipour, you're okay with all this?
Yes, but I'm not kind of okay with the parking condition. But if that's the law and it has to be there, so it has to. But I'm not sure if, because right across this property there was just a semi-detached was built, and I'm sure they were severed. And I want to make sure, I want to check to see if they have this condition as well or not, or just us.
We don't know that, right? So yeah. I can't tell you that at all. So, but in this case, the advice that we're getting is to include it. We've already modified it, so it's less time particular.
Yeah.
So,
but the plan has only the one parking, and the city, as Mr. White said, the city bylaw is controlling the street, and why the street control should be just parking. I don't think it should be there at all, but if it has to be there, so it has to be there. I don't know.
Okay. The
doesn't make sense to me.
Well, I was going to explain to you, the intent really is to protect prospective purchasers, so that prospective purchasers understand the limitations when they buy. That's the purpose of this clause on title. Otherwise, they would just use bylaw to enforce.
Yeah, but the driveway has only, it's not possible to park 2 cars. But for selling this property, it will give us some kind of difficulties. That's what I'm looking for.
Okay, well, I guess what the city is saying is that in the public interest,
okay,
making that available, making that obvious to any prospective purchaser is what they're recommending. Okay.
Okay.
So we're going to stick with it. Okay. And with that, then I do need a vote. So members, all those in favor of this application? All right, for the record, the decision is unanimous, so the application is granted subject to the conditions as stated, the additional condition on parking as revised. All right.
Thanks very much.
Thank you very much.
Thank you. Have a good night.
Have a good evening as well.
Thank you.
All right, we're on Paget Road. So 2368 Paget Road, it's number 11. Looking for, I believe the agent is Ms. de Courville. Yeah, I think it's Ms. de Courville Nickel. Do we have the, yes, I see. All right, so. Good evening.
Bonsoir, Madam Chair, committee members, good evening.
Bonsoir. Est-ce que c'est Madame Courville Nicole? De Courville Nicole?
De Courville Nicole.
Nicole, OK. Ah, j'ai pas de Nicole, c'est pas ça que j'ai décrit. OK.
Aucun problème.
OK. Est-ce que vous êtes d'accord de procéder en anglais ou en français?
Oui, absolutely, yes. Yes.
Very good. I just always want to check that. So
I didn't even realize I'd switched over.
Okay. Well, with that, then let me just read the solemn declaration. So do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted first at the property to which the application applies, that it was there for the prescribed number of days prior to the hearing, and that it was clearly visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
I do swear that to be true.
Excellent. Just a couple of housekeeping changes to your legal description in the notice. My understanding is that we correctly identified part of Lot 6, Concession 3, Ottawa Front, but that we're also adding and Part 8 on reference plan 5R 4980. Is that correct? All right, this is a bizarre. Okay, so Ms. Ramirez, I need your help here because I have conflicting information. In one case, on your report, I have the striking of that information. And on the summary, I have the addition of that information. So which one are we doing here?
So thank you for the question, Madam Chair. The notice went out with that Part 8 of Reference Plan 5R 49080, and the plan of survey doesn't reference it. And when I looked at that plan, it looked like it was almost like a reserve, and so staff doesn't believe that it's should be included in that, but I leave it to the applicant to confirm.
All right, so very good. So then, in fact, we're striking it from the notice, not adding it. Okay, so I guess, so I'm looking for your then confirmation of that information. Ms. de Courville, Nicole?
If that's what the planner has stated, I have no way of double checking that right now, but I assume then that if that's correct, that's correct. Yeah, I have no problem with that.
All right, and I think that's the only change that we needed to make to the notice on this application. So, okay. Again, in your case, not looking for a presentation. The committee members have had a chance to go through this application fairly thoroughly. So I'm going to open it up to questions, though, to see if there's anybody who may have a question at this point. All right. No questions from anyone? Oh, Ms. Willis, sorry.
Yes, Madam Chair, thank you. It was actually a question for staff, and I'm seeing that staff has an issue with the layout of this lot. And I'm just wondering if we can get an explanation from staff as to why they have a problem specifically, and whether further information might help make a positive recommendation for this lot. So, for example, layout of the proposed house.
Ms. Ramirez.
Thank you for the question, Madam Chair. Staff have concerned with the flag lot, separate the flag lot, and the applicant did consult, and staff expressed concern in that pre-application consultation, and staff continue to have concerns. It creates a house behind that true public street, and it will increase the amount of hard landscaping that is in the front yards. and staff does not believe it's an appropriate, it fits in this context.
Is staff concerned of the ability of the applicant to come back with a design that requires variances? Or is that what the concern is? Is that one of the concerns, that there's been nothing proposed and it may require variances, which may end up being a problem if the severance has already been granted? I also wonder whether or not it would be more appropriate in terms of the layout where the house would be more visible, or whether it would be preferable for staff to have it hidden behind the existing. I think I know the answer to that one, actually. I'm just wondering whether or not additional information would have convinced you otherwise.
I think, through you, Madam Chair, I think design can definitely play a role in determining if something is compatible. There was no site plan, no design that was provided. And I have seen examples of this in other areas where hard landscaping dominates the front yard, and that's not desirable. And we want soft landscaping in that front yard. And we also want living space to be adjacent to the public street. I think that a rectangular lot would allow for that living space to be brought closer to the street.
Thank you.
All right. Thank you, Ms. Ramirez. Mr. Handel, you're next.
Thank you. Mr. Ramirez, I think maybe pulling on that thread that you talked about. So the flag or the pole portion of this flag lot is still 10 meters wide. So greater, we build houses quite regularly in the city that are smaller than that, in more than 9 meter range. So in this case, is it the issue that there is that flag portion? So if it was just the 10 meter lot and straight back, that there wouldn't be a concern? It's more that the fear is that ultimately a larger home will be built at the back in the flag portion, and then the 10 meter wide pole portion will be left as really just parking and access?
That is correct, Madam Chair. Member Hindle has recapped it very well.
Okay, good. No, I just wanted to make sure. So in this case, like, it's not before us, but this lot could have been easily three 10 meter lots that would be in a traditional configuration. But so the concern here is really just that back flag.
Yes.
Okay, thank you.
Other questions from committee members? Right, I do have a question about what the future use is of that portion to the back. Is there anything that you can tell us, Ms. de Courteville-Nicole, about that future use?
Yes, absolutely. I do intend to build the front facade of the house and the garage in the what's called the pole portion, and starting it there. I think that it is very important to be able to balance the view from the street. The only way to do that is, as I stated in my submissions at paragraph 16, I believe, that the garage and the main entrance and front facade would be concentrated to the side or the right of the property, and it would basically be like an L shape. As for the issue of hard landscaping, or if it can help, the idea here is absolutely to add soft landscaping. If you perhaps recall the image 1 in my submissions with the actual house or the current house that is on the property, I've worked very hard to embellish it, actually, to even out the roof lines, add a large veranda, adding to the livability and the curb appeal of the home, and so that the residents can really enjoy the property a lot more, because before, historically, from what I've seen, it was more big trucks and the like on the front sides of the property, and very large driveway leading to two big large garages at the back of the property. So what I'm trying to do is absolutely, it's part of how I design, or I like to develop things, is to work on embellishing and also take into consideration neighbors and the community. And because of the mix of houses there, and I felt that it was very important not to create deep, narrow lots that often the only way to build is to build up these narrow rectangular boxes that I don't feel personally that, design-wise, that it was in the interest of that particular lot, because the neighbors are not set up that way at all. And so there could be issues with light, visibility, that type of thing. I don't know if I've answered all.
So I just have a couple of follow-up questions. So you seem to have a very specific, like a very detailed idea of how you would have developed, you're going to proceed with the development of that flag piece. Did you share any plans with planning staff or committee staff in that regard?
No, actually, and I realize now, my discussions where there was, anyway, with planning, I didn't realize, and I wasn't asked whether that would be useful, but I certainly sent in my application, I don't know if it's possible to pull up 7B. It shows in highlighted yellow format where I've been trying to prepare and develop the, I don't know if you can see properly there. There's a yellow line. It's not very visible, but that's where I've been trying to concentrate the footprint somewhere in there to develop it. Because it has to be on that side. I did send in, actually, when I saw the comments earlier or yesterday received from planning, I did send in a few pictures of concept drawings to show you or give you maybe a better idea of what it is that I'm trying to achieve on the lot. Is it possible to pull up concept drawing number 1? Okay, and it's a very rudimentary, it's obviously my drawings, but you see that the garage would be forward, and the main entrance, I'm looking to do a covered type of entrance towards the back there, and that portion would be centered with the pool area. Could you please pull up concept drawing number 2? This is another rendition of what I've been doing. It was very hard for me to conceive the plans without knowing the parameters of what I was allowed to draw in. And that's where, before investing huge amounts of money, etc., I wanted to make sure that in order to respect what the limits of it was, that I would get permission first to do the severance. But I do have a very clear vision on how I want to do this in order to make it an attractive home and property that the neighbors will also appreciate. I have actually concept drawing number 3 too.
Sorry, I was just going to ask you a follow-on question about your consultation with the neighbors. Can you tell me a little bit about that?
Yes, my immediate neighbors I've spoken with, and my colleague and I have gone around and had good discussions with them. Some people also, while we've been working on the renovations of the existing house, have stopped by to say hello, and we've shared the plans. Unfortunately, with the pandemic and with the number of houses in the community, I haven't been able to obviously share my plans with everyone. But I've had nothing but good feedback and support from the neighbors that were made aware of the plans.
All right, and did you just, by any chance, did you reach out to the community association?
No, I did not for that because I'm new to the area. I didn't know that the community association, whether it would be interested in that particular development, because there's so much activity everywhere going on. I'm just a little a little lot, and I figured if they had an issue, I would hear about it, and I would certainly otherwise have discussed it with them if I thought it was they would have been interested.
Okay. All right. We just I don't know if you heard me earlier with another with another agent, one of the things that we do try to foster is for developers to speak with the community associations as part of their application development process. So anyway, just thought I'd mention that because neighbors is very, very grassroots, as you know, for people. You know, when something's happening next door, they like to be consulted.
Absolutely. I sat down with many, and actually it was kind of nice to get to know everyone. It's a good way of doing it.
Excellent. Glad to hear that. All right. So any other, so I've asked some questions. Anybody else in the panel have anything that they'd like to explore? Mr. White.
Yes, Madam Chair, I think we're in a difficult situation, not having any commitment to design issues here. Strikes me that, I mean, from what I'm hearing from the staff report is that there's opposition to flag lots in this particular neighborhood. I'm not so sure if flag lots are discouraged elsewhere, because I'm sure that we've seen these things in the past in other locations. I think that's the difficulty I'm having is the design issues. I mean, there are things like the suggestion that green space is going to be we're going to lose some landscape green space at the front of the property. Does that necessarily have to be so if there is an exclusion of access to one, for both units, access to one laneway serving the two dwelling units? In other words, it'd have to be a access arrangements and easements, rights of way, etc., on the property to accommodate that. But yeah, I'm just having some difficulty with the fact that we don't have any design concept or way to with the application as it's submitted, way to sort of commit to some of those things that would likely make it more palatable.
Okay, agreed, Mr. White. Any other questions? No, I'm getting the panel members first. I want to get their feedback. So, all right, okay. I thought I had another question, but go ahead, Ms. de Courville, Nicole, sorry.
Not at all. I was trying to pull up actually the, I guess the general site plan. I did send in a concept site plan to give you a visual.
So I guess what Mr. White is saying is we need something a little more detailed, a little more thought through in terms of being able to demonstrate compliance to the, even in the back lot, to the zoning bylaw standards and that kind of thing. So I think, so we've seen your concepts, but I think Mr., and I don't, not to put your words in your mouth, Mr. White, but I think that what we're suggesting is that's probably not enough from a design standpoint to really give us some comfort about how the development in the back is going to proceed and how it relates to the overall development of the two parcels.
If you would permit me, I was trying to get it up a few minutes ago. It does have a lot of detail. I've actually put a lot of thought into it. This is just to give you an idea, but that's basically, I was looking at a detached garage option or having it attached to the house, but it would not be very different from that. Again, because of the setback requirements and whatnot, building within, I needed to know what those setback limitations were in order to be able to fit a design that would be amenable to that space, because I'm looking to keep the building low relatively, and for it to integrate into the landscape and the neighboring properties. And as well, definitely, you probably, I don't know if you can see it, but there's a lot of hedging. I'll be planting a lot of trees. Privacy, right now, the lot is extremely just barren, open. You can see in everybody's yard. And this is basically would be my approach. I was looking for a middle ground, how to find the middle ground between having a very narrow lot where you have to build up and high, and having something that permits a similar type of structure as the other neighboring houses.
All right, thank you for that explanation. Okay, just so I think I did ask, because there wasn't anybody that was on my speakers list.
Madam Chair, we do have one speaker.
Oh, we do have one speaker, Mr. Leach. Yes, Mr. Leach. Sorry, my apologies. All right, so with that, then if the panel members don't have any more questions, then we'll hear from Mr. Leach.
Madam Chair?
Yes, Ms. Willis.
Yes, I have a question for the applicant. Did you go so far as doing your concept plan to see whether or not all the setbacks that you're showing there comply fully with the zoning bylaw and that no further variances would be required in order to give the building form and the footprint that you're showing?
It was my understanding. I've looked at all of the zoning bylaw requirements, and my interpretation, which I also, because I'm actually a trained lawyer, and as well someone else I consulted to confirm my interpretation of the front lot lines. Absolutely, I spent time trying to make sure that the parameters were okay.
So the front, the soft landscaping, the driveway width, all that sort of thing in the front yard would comply fully with the zoning bylaw?
According to, yes, from my understanding. I haven't heard any differently. Hopefully, well, I did actually pose the question initially for confirmation, and it was unclear in my discussions. And so I made sure to go through everything and also get a second opinion on it myself. Yeah.
Okay, thank you.
All right, thank you. Further questions, Ms. Willis?
No.
All right. With that, then I think we'll go to Mr. Leach.
Good evening, Madam Chair. You can hear me okay?
Yes, we can hear you.
All right. Thanks for the opportunity to speak on this issue today. You know, when we received this notice in the mail last week from the City of Ottawa, we did have concerns that came to the forefront, and in talking with our neighbors as well. You know, concerns about, you know, what the impact of this lot severance would be on the neighborhood and the precedent would set, and concerns about any future development, because although we heard some today, but this is the first that I've heard of these types of concepts. So I guess I've learned a new word today, the flag lot. I guess that's our concern is you know, that flag aspect to it, and you know, whether this is actually compatible with the surrounding area. I think it comes down to the fact that, you know, there will be a home built in people's backyards, or, you know, what is a backyard right now. And that certainly wasn't part of our expectations of buying here, or the neighbors that we've talked to. So there is concern about this type of intensification and splitting the lot, but again, that flag aspect of building a house in the backyard, I guess, is really the biggest issue. And from a precedence perspective, I suppose our concern is that we're setting ourselves up to potentially have a new row of housing in between two existing rows of housing all the way up and down Paget Road. So that's a concern that we put forward to the committee. I think that you know, we've seen sheds and we've seen garages built in the backyards, because they are big lots on Paget, but that's something different than having a house built, and some of the concerns with obviously the privacy and et cetera that you get into. You know, I think that the lack of details up to this point has been a concern, just in terms of what size of house, or the setbacks and number of floors, et cetera. I think you mentioned it off the top that neighbors get concerned about these things and have questions when they come up, and this is our concern at this point. So just in summary, I mean, I just wanted to let the committee know that you know, the flag lot and building, the impacts on the neighbors and building in the backyard is a concern that we have. Thank you.
All right, thank you, Mr. Leach. Any questions for Mr. Leach from the panel members? Okay, that was the only name that I believe we had. So I'm going to make a call out there to anyone in the audience who's listening in who may have an interest in this application. If you'd like to speak either for or against, now is your chance. All you need to do is raise your hand, and the committee members will let you in, the coordinators. All right, I'm not seeing anybody come forward, so we can either deliberate, panel members, or we can go to a vote at this point on this application. All right, I think we can go to a vote then. I'm not seeing anybody come forward with any other comments they want to share. So, so with that, then all those in favor of the application. All right, so we've got 3 panel members in support of the application and 2 in dissent. That would be myself and Ms. Willis. Ms. Willis, would you like to articulate your reasons for your dissent?
Yes, I think that in a case of, there are other areas in Orleans where there are flag lots, little developments of flag lots, but they go through a whole other planning process, as I understand it, where you would see the layout, there'd be agreements with regard to access, how the driveways are shared and all that sort of thing. And I don't think that's the case here. And I do sympathize with Mr. Leach's view that this could lead to a whole second row of houses tucked behind existing ones. So it's not that I have a problem with flag lots in general. It's just, I don't think we have enough information at this time to ensure that this is orderly development.
All right, thank you. Those are essentially my reasons as well. So I don't believe it is in fact demonstrating and that it's in keeping with the context of surrounding lots. And so I have a concern with it as well. So with that then, as it works out though, we still have 3 in support. So the application passes and is granted. So with that, then there are a number of conditions, Ms. de Courville-Nicole, that you're aware of?
Mm-hmm. Yes.
Okay. Just want to make sure that you've had a chance to look at all that and that you're don't have any questions about your conditions to this application. So, all right. Well, thank you for your time this evening.
Thank you. Thank you for your time.
Okay. With that, then we are on to application number 12. So this is 305 Leggett, looking for Ms. Newcomb. All right, Ms. Newcomb.
Hi, good evening. My name is Tyler Patton. I'm acting as an agent for the owner, but I see that Ms. Newcomb is on as engineer 1.
All right, so who's going to speak to the application then? Either Ms. Newcomb or yourself, Mr. Patton?
Sure, so if I'm happy to speak to the application.
All right, so I need to start with the solemn declaration first, though.
Sure.
So who should be doing that? Yourself?
I believe it should be Ms. Newcomb, but I'm comfortable with it as well.
Ms. Newcomb, Mr. Patton, do you work for the city as well?
No, I do not. I'm a consultant. I work as a consultant for the city. I work for Jacobs Engineering Group.
All right. And you can attest to the sign posting? All right, in which case, well, let's move forward with you then. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted first on the property to which the application applies, that it was there for the prescribed number of days prior to the hearing, and that it was clearly visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
I do affirm that to be true.
All right, thank you. On that, not looking for a presentation on this application, do have to make a couple of changes though. So I need somebody to confirm this for me. On the legal description, I just want to make sure I go back to the notice because I got caught the last time. Okay, on the legal description, we are changing Plan 5R 2607 and instead adding 5R 2807. Is that correct? Or actually, we're adding it. So both of them apply. Is that correct? I guess maybe I'm looking at Ms. Cully. I want to be sure I'm getting this right. Ms. Cully, so we've got reference plan 5R 2607. Are you suggesting that 5R 2807 is missing?
Okay, Madam Chair, 5R 2807 is the correct one. 5R 2607 was reported but is incorrect.
All right, so we're striking it. Okay, just want to make sure we're doing that. Okay. In agreement? Mr. Patton, Ms. Newcomb?
Yes, thank you.
All right, okay, good. I think, oh, and then we only have one more on the notice to change. Had to do with the zoning. So the zoning is shown as IG6. And in fact, it's IP6 bracket 1549 bracket and IG6. Are you in agreement?
Yes, yeah, I understand that it's 2 lots and they have a separate zoning. I'm in agreement of that. Thank you.
All right, excellent. With that, no presentation required. I'm opening it up to the panel members to questions at this point. It's pretty straightforward. There was a lot of good explanation in it. So any questions? Nope. All right, on these variances. Okay, with that then, do we have anyone that's, just want to make sure nobody's raising their hand. Okay, we don't have anyone to speak to this application. So let me just open it up to the audience. Is there anyone who would like to speak to the application either for or against at 305 Leggett Drive? And it's to permit a reduced front yard setback and reduced setback for watercourse from a construction for a new control and pumping station. Okay, I'm not seeing anybody come forward. All right, so I just have one, before we go to a vote, one little thing that I want to address. Ms. Cully, we have a condition of approval to a minor variance. As you know, we don't typically have conditions. There's no way to clear the condition. So we were going to suggest that we simply make note of the condition as an additional comment so that the applicant agent is fully aware of the requirement for a stability of slopes. Unless you can tell me how we can ensure that we have the enforcement of this condition.
Madam Chair, from my understanding, minor variances can be conditioned. It's rare, but they can. And in this case, the engineer has indicated that this condition would be required because it's not something that can be achieved at the building permit stage. So if the condition cannot be added to the minor variance application, my understanding would adjournment would be required because that is necessary in this application.
So we can add a condition. We can add conditions all we want. There's no way to enforce them on minor variances, which is kind of where we were at. And we're kind of thinking, not sure that that we want to do that here. But I see that Ms. Ramirez has her hands up. Great, we're gonna learn something here on how to do this. Go ahead, Ms. Ramirez.
Thank you, Madam Chair. Ms. Cully is absolutely right. We have on occasion used conditions in minor variance, and the wording that has been, I used it, I want to say it was 66 Chippewa, and it was related to tree concerns, and the wording that was used was that no building permit would be issued until I believe it was related to tree information report and a grading plan were submitted, and we took securities for the tree. And so when the building permit folks are doing their review, the plans examiners won't do their review until the condition has been satisfied. So we don't have a really good way of flagging it except reaching out to those in building permit to make them aware of the condition. But we have said before that no building permit will be issued until the condition has been satisfied.
All right, so we don't have the building condition or the building permit as part of this condition, unless I've missed this. It's not there. So in other words, I'm not sure how we would flag this. Ms. Cully, what were your thoughts?
3, Madam Chair, I do know the zoning plans examiner that is responsible for this application, so I can reach out personally to ensure that she's aware of the condition, if that is of any help.
All right, in which case, unless members of the panel have any issue, we'll keep the condition. I need to understand that better, I'll be honest with you, because I guess because you've developed sort of the relationship with the plan examiner makes some sense. They know that's coming, but typically there's not a lot we can do. So, all right. Okay, with that then, I think we can go to a vote. So all those, Ms. Ramirez, your hand is still up. Did you want to address the committee?
I forgot to lower it, but if the wording can be inserted at the beginning that no building permit will be issued until the condition has been satisfied, that also gives another flag.
Okay. At this point, I'm willing to live with it the way it is, unless anybody tells me. I was ready to get rid of it, so that's the direction I was going in. So, okay. All right, Mr. White.
Thank you, Madam Chair. I think what we're talking about is the same thing as you don't get a building permit to build this particular dwelling unit because it doesn't comply with zoning. You won't get a permit until you have a minor variance. So it's very similar to that scenario, I think. Just as a comment, I'm a little bit surprised to see an application like this before us anyway from the municipality when if the zoning bylaw has provisions that allow for public utilities and infrastructure to be located in any zone, as long as they're in substantial compliance with the zoning bylaw, we wouldn't be having to deal with this. And that's a lot of zoning bylaws have that kind of provision. So it eliminates the need for committee adjustment approvals, but I guess we don't have that in this zoning situation. But anyway, I think the condition can be dealt with by building without any problem.
Okay, I've seen that too, by the way, Mr. White, where for things like this, you don't need to go back. It's sort of an as of right thing. So anyway, okay. All those in favor of the application with a condition as worded. All right, so it's unanimous. The application is granted and subject to the condition as worded. Very good.
Perfect. Thank you, Madam Chair. Thank you, committee.
All right, thank you. Okay, we're on to the next application here. 1634 Ortona Avenue. Looking for Mr. Segreto again. Hello again, Mr. Segreto.
Good evening.
Okay. On this one, I'm going to read to you, and then we're going to go to questions. So do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies, that it was there for the prescribed number of days prior to the hearing, and that it was clearly visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
I do swear.
All right, thank you. Okay. We're going to go straight to questions on this, and I think there may be some, Mr. Segreto. From panel members. It's awfully quiet. So, Mr. Handel, go ahead.
Sure, Mr. Segreto, this application has a ton of parking. Can you give us a bit of an overview as to why that scene is required in this case and why it's reasonable as in the way that it's been designed?
Well, if I can go quickly through my PowerPoint with you and I can show you how we've got to this stage, I'd be more than happy to explain it to you. Can you kindly just...
I was going to say, how about we get the site plan up and then you can speak to the site?
Sure.
All right, let's do that.
Well, can you go back one? I just want to show you the house. Back to the first one. That's the subject property that's in front of you, and you can clearly see that there's an older home there, a two-story older home, probably built in the 1930s, 40s. And obviously what my client would like to do is build himself a brand new two-story single-family dwelling. The lot itself is 98-foot frontage by approximately 227 feet deep. If you can go to the site plan now. site plan. So you can clearly see at the top of the page where we have our driveway and then we have the house. My client would like to have a 2-car garage for this particular house. And in addition to that, he'd like a driveway to go to the back where he is proposing to construct a coach house for his in-laws. So
sorry to interrupt you, Mr. Segreto. So going back to Mr. Hindle's question then.
Yeah.
So Mr. Hindle's question to you was, why so much parking attached to the coach house?
To the coach house?
Well, I think in general, there's a lot of parking. Can you just tell us a little bit about that?
Well, these guys have cars, so they have sports cars. I guess that's my guess. But if there's an issue with some of the asphalt in the back for the coach house, I can reduce that to a 1 lane there rather than having the 2. I can put reduce the asphalt in the back or the permeable type of driveway there. That could be reduced in the back. If he's asking me that question, I can do that. But I do need access from the front to get to the coach house in the back. I don't know if I've answered the question or not.
Mr. Hindle, did you want to follow up?
Well, I guess that in the rear, it's not necessarily, relevant to this application because we're dealing with really the front yard driveway portion fundamentally as part of the variances. So what's in the rear is to some extent immaterial.
So Mr. Hindle, if you look at this, the design of this house, which my clients really would like to do, if you can just go to the next page, please. The front elevation of the proposed dwelling, please. Existing, yeah, next. Okay, so basically this is the house that my clients want to build on that street. And you can clearly see that there's the 2 garage doors. Therefore, when you look at my site plan, you can clearly see that I do have some asphalt or interlocking, or we can put the grass paved driveway there. Now that variance that I'm requesting there is a variance now of an abundance of caution, which I'm asking for. Back in August, when I did make this application, there was no concerns with that at that time. The only concerns that they had with me, which planning had with me on their report back in August, was that did the coach house in the back comply with respect to the setbacks, so on and so forth. That was the main concern that they had. This is a new concern that they're bringing up now, but back then there was no concern on that whatsoever. And the other variance that I'm asking for obviously is when you look at the front entrance, you can see the brown door in the front. That's where the front entrance is what my clients would like to do, is they would like to have some sort of a covered porch. Therefore, the garage portion is just pushed out slightly with respect to this design. It's all in the design of the house. The evidence that I do have, if you continue on my PowerPoint here, is you can clearly see that on Ortona, this is the site plan. That's basically lot grading and drainage. This plan here is just showing you the areas where the photos have been taken care of, the lot fabric. If you can go to the next photo. Now you can clearly see at 1595, the door is set back, the garage is pulled out front, there's interlocking off to the one side. At 1605 Ortona, you can see the same thing. The garage is pushed out front, the door is recessed back. Next slide, please.
So, Mr. Do you know by any chance what dates those builds would have happened?
These, Madam Chair, would have been done, I would say, in the 80s and in the 90s, and some of them in the 2000s. I've done quite a few in the Carlton Heights area, and some of these are my designs that I may have done 15, 20 years ago. But again, as you can see on the photographs, with the asphalt, with the interlocking, and with the doors that are recessed back. Next slide, please. Some more pictures of evidence of houses which have the driveways. The long driveways, due to the fact that these lots are all 200 feet deep or so. What I can suggest is, with respect to the question that the gentleman has there with respect to the asphalt or the driveway, we can go with that grass driveway, and I can screen it with shrubs as well, if that would help out, and if the planner would be willing to look at that as well, I could revise the plan accordingly. That's basically it.
All right, thank you, Mr.
Yep.
Segreto. Any further questions from the panel members? Ms. Willis, please, go ahead.
Not relating specifically to the variance requested, but I just wanted to confirm with staff that I know there's limits on the size of a coach home that is permitted in the backyard, and I see that this one is, I think, 80 square meters. Is there no limitation on the number of garages or total floor area of the footprint of the building in the case of a coach home that would make it not possible to build this?
For you, Madam Chair, during the first review of this application, it was identified that the coach house was too large with the combined garage for the aggregate total of accessory structures. It was then revised as a result of those comments, and the current structures as proposed would be compliant.
And is it maximum size it could be?
I would have to double check my notes, but it is quite large, yes.
Okay, so the issues only that we're dealing with here are the projection of the garage in front of the house at the front of the along the street frontage, and I actually think looks like a nice design. The width of the driveway is just. Is there anything you've tried to do, Mr. Segreto, to try to mitigate? You've suggested maybe landscaping to soften maybe the appearance from the street with all that pavement in front of the house. And when you were talking about putting turf stone or something, are you talking about into the backyard, or are you talking about the front as well?
More so in the front. And I think to compensate as well a little bit with respect to the entrance where we have 6 meters that open up to the road. If that becomes a little bit of an issue, we can reduce that 6 meters down to 5 meters or possibly even 4 meters rather than having it 20 feet wide at the front. And I can provide all that sort of turf driveway if you'd like all the way. And I think my client would be willing to do it all the way down to the back. There is quite a bit of green space on this property, as you can see in the backyard and off to the side. If you look off to the side, you can see there's a number of trees. There's about 10 or 15 trees where the coach house is, where the orange area is on my site plan, but all those trees are being preserved. And along the side, there's a buffer from the orange. You can see that all along there's green space along there, and then there's all the trees in the back, that's green space, and then in behind. So there is a fair amount of green space in front of this property. And also in the front, if you can just lower down the site plan a little bit, you can see where the driveway is, and I'm willing to reduce the openness going out to the street to maybe 4 meters or so. The existing tree that we show there, it's a city tree, I believe it's to remain, but there is additional green space all along that side. So you're looking at probably 80 feet, 70 feet of green space. And where the driveway is, we can easily screen that with some shrubs. We could put all kinds of shrubs around there too, just to hide a little bit of the driveway look.
Okay, thank you.
All right, any other questions from members of the panel? Okay, if not, then I'm going to see who we've got.
Mr. Hindle has.
All right.
Sorry, didn't saw. I looked, and sometimes I don't see off. Right
No
away.
worries.
My apologies.
So, Mr. Segreto, I think kind of building on my first question, I have a bit of a bugaboo with variances that are just for parking, especially for a lot of parking and a lot of driveway in this situation. Was there other options considered, such as turning the garage sideways and other options so that we don't have 14 meters of driveway in this case?
Well, there is. You'd have to take the house and slide it over. I believe we could slide it over towards the north where we have the 2.17 meters. You go down to 1 meter over there, and you get fairly close to that house that's off to the side. If you can go to the site plan for a second. So if you take the house and you're moving it towards the right, right there's about two, as I said, 2 meters or so. But then you start to get a little bit close to the 1640 that is there, and what happens is you need approximately 30 feet if you want to get in, to have a turning radius to get into the garage if you want to come in from the side. And we've looked at that, but again, you would need approximately 30 feet. And my clients just love the look of this house, and this is sort of their dream home that they want to build. That's it.
Okay, and then in this case for this application, like I hear you on the elevations. You know, they're relatively attractive. The material that have been, you know, you've done some clear desire to use some glazing to break up the garaging, but to me it's the fundamentals of the application, especially just because they're related to parking and to pushing the house behind parking, which is always just a bugger.
What if I make a suggestion? What if I, right now there's 2 garage doors there when you're looking at the site plan. What if I go with one 18-foot door, and then I'll create, if I do an 18-foot door, if you can kindly go to the site plan for a second.
Well, Mr. Segreto, before we go there, so I think what I'm hearing a lot is that we're redesigning this thing, the site plan, right now, right tonight. And I don't mind looking at minor things on occasion, but I don't want to redesign the site plan as part of our discussions, because if we're going to do that, then I want it to go back over to staff, and I want staff to have a good look at it and come back to us with a revised report. But I don't think we're going to start doing all these changes. If it was minor, Mr. Segreto, that would be one thing, but we've been talking about all kinds of different things right now. And so what I would prefer is if you're more comfortable, if you wanted to start addressing this, because I haven't really given my side yet. I've been letting the other members, but I have a real concern with a particular your variance B. So if you think there's a way that you can take this back and that you can rework some of the design on the site plan and then come back to us with something that seems to be a better fit, that's a little less, you know, not stretching the limits on the width of the, you know, the hard, and if you're going to propose, for example, different types of driveway materials, then to me, take the time, go change the site plan and come back to us.
Okay, well,
so
let's adjourn it for 2 weeks, and I'll come back in 2 weeks.
All right. Okay, I'm going to go to Mr. White first and then Ms. Cully.
Madam Chair, we're agreeing to adjourn the application for a couple of weeks to tinker with the design. Could I ask if it might be possible as well to simply push the main dwelling unit back a little bit to beef up the landscaping area in the front of the unit? That might help soften the driveway component. Quite frankly, I don't see the advantage of going to a turf stone type of driveway. You're still going to be putting cars on it and driving cars on it. There's no, from the perspective of the view from the street, there's not a lot of change, not a lot of impact, positive impact of that stuff. So I just suggesting, if we are going to be going back looking at things, one of the things I might point to is possibly pushing the main dwelling unit back a little bit to beef up that landscape buffer area that I think Mr. Segreto's indicated he can screen the driveway with shrubbery, etc.
All right, well, let's do that then. Ms. Cully, your hand was up. Did you have a comment you wanted to add?
Yes, through you, Madam Chair. I just wanted to highlight to the agent that this is in the Carlton Heights secondary plan area, and there is the new policy within that secondary plan, which states that no new driveways can be implemented on the property, and revisions to the plans might bring that into question. So I just wanted to highlight that because there might be some strategic driveway configurations that might need to be explored, because my understanding is the only way to avoid that being in contention with the official plan is to use the existing driveway area. And I think the driveway as proposed would far exceed that.
All right. Okay. Sounds like there's some discussion to be had then with the agent. Ms. Markovich, I know you had your hand up earlier. Did you want to ask a question or make a comment?
No, I had just, thank you, Madam Chair. I had only just been interested in learning if in the whole process of revision, if there had been any further consultation with neighbors and if there was any kind of feedback for that process that Mr. Segreto could speak to. That was all.
Mr. Segreto?
My understanding is that I know that Mr. Bocelli has talked to the abutting neighbors. I believe he has. As I always do, I ask my clients to talk to the abutting neighbors. I can get back to you on all this stuff, but from what I understand, there was no objections from anybody in the neighborhood in this particular area.
Thank you.
Okay. All right. Thanks so much. I guess with that, then I'm going to propose an adjournment to April 6th. All those in favor? All right. Okay. So Mr. Segreto, we're going to give you some time to work through some of these things and to come back with a revised plan. So good luck to you, and we'll see you in 3 weeks.
Thank you.
All right. Thanks so much. Okay. All right, let's go to number 17, which is for 21 Girvan Street. Looking for Mr. Cooper. You're on mute. Oh, now you're good.
Yes, are you able to hear me?
Yes, I can. Did you want to come forward with your camera?
Yes, certainly. Good evening.
Good evening. I'm going to need to start by reading something to you. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted first at the property to which the application applies for the prescribed number of days prior to the hearing, and that that sign was visible and legible for the entirety of that time? Do you either affirm or swear that to be true?
I affirm that to be true.
Perfect. Another housekeeping change that we need to make to your notice. So we are adding the reference to parcel 43 to your legal description. Do you confirm?
Yes.
All right, perfect. With that, not asking for any presentation this evening from you on this, so I'm going to open it up directly to the to questions from the committee. I know this was adjourned from an earlier meeting. So any questions from the committee on this proposal? For its minor variance, we're looking at 4 variances. Any questions on this? Mr. White?
Madam Chair, could I just get confirmation on the setback from the property line to the actual garage that appears to be the issue here? What is the distance from the property line to the garage? And also, if we have that information, to the actual paved surface of the road.
So I don't know that number off the top of my head, but if I'm able to, if you're able to share the site plan, or at least if I can, let me just see here, actually, I can look at my site plan. So the actual dimension for the proposed setback to the front property line to the corner of the enlarged garage would be 11.34 meters. And then the actual setback to the edge of the road, Mr. White, I think is what you were asking for?
Yes, if you have that, yeah.
I don't actually have that dimension. It's another, I'd say in the order of 6.5 meters.
So the total roughly would be from the paved surface of the road to the offending garage would be what?
In the order of 18 meters.
Thank you.
It's significant.
Thank you.
You're welcome.
All right, any other questions from committee members on this? So you've got a couple of, you've got at least one minor variance, Mr. Cooper, that is regularization, really, on the lot area.
That's
and the
correct.
rest, the other three are completely tied to the development proposed?
Yes.
Okay, wanted to confirm that. All right, I don't have any questions on this. All right, okay, then let's go to our speakers list and see if we have anybody listed. Yes, we do. So we have Ms. Mary Osborne and Mr. Andrew Bird listed as speakers. Would you like to come forward?
Madam Chair, I do not see them on the call.
They're not there? Okay. In which case, I'm just going to make a general call out to the audience. Is there anyone who would like to speak to this application either for or against? Now is your chance. It's getting late. Sometimes we start losing people that really wanted to participate, but it gets late sometimes. So, all right, I'm not seeing anybody come forward. All right, committee members, minor variance. We've seen this one before, just briefly. If you have no other questions or comments, I'm going to go to a vote. Okay, all those in favor of the application? All right, for the record, the application is unanimously granted. And so with that, Mr. Cooper, thank you for your time this evening.
Thank you very much. Good evening.
Good evening. Okay. We're on to application number 18, and this is for 3 Harold Place. Looking for Mr. Smith. We've been looking for Mr. Smith. Yes. Good evening,
Madam Chair. Hello.
Good evening. I'm going to read to you. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted first to the property to which the application applies, that it was there for the prescribed number of days prior to the hearing, and that it was clearly visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
I affirm that to be true.
Excellent. I don't believe there's any changes required to your notice, so we're good on that side. So I'm going to open it up directly to questions from the committee. Mr. Hindle, go ahead, please.
I just wanted to say, Mr. Smith, I was very happy with the package you put together. I thought it was very well clear and coherent and addressed kind of everything that we're looking for. So kudos very much so on this application.
Thank you via the chair, Mr. Hindle.
Always makes our job easier when we have that information, that's for sure. And that shows sometimes when there's a few questions. So, all right, with that then, no one's on my speakers list. So is there anyone in the audience who would like to speak either for or against this application for minor variance at 3 Harold Place? Okay, not seeing anybody come forward. So on that then, we've got, we can go to a vote. So all those in favor? All right, for the record, the application is unanimously granted. So thank you for your time, Mr. Smith.
Thank you, Madam Chair and committee members.
Have a good evening. All right, that leaves us with 2 applications to deal with. The first one's number 10, and it's for 12 Viewmont Drive. And I'm looking for Ms. Gibson. Ms. Gibson, I can see you there. Just need you to.
Hey, good evening. Are you able to hear me?
Yes, we can hear you and we can
Perfect.
see you. So that's marvelous. Okay, so I am going to read to you and I need you to respond. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted first at the property to which the application applies, that it was there for the prescribed number of days prior to the hearing, and that it was clearly visible and legible the entirety of that time? Do you either swear or affirm that to be true?
I can affirm that.
Perfect. We also have a number of changes to your notice. So with regards to the legal description, what I'm understanding is that we are going with part of lot 32 and we're striking 12, concession 1 Rito front, and then we're adding parcel 259 in the geographic township of Nepean. Is that correct?
Yes.
Okay. Moving on to the description of the lot depths. From what I understand is the severed land, which is parts 1 and 2, has an irregular depth of 86.69 and not 84.12. Is that correct?
That's correct.
And the same is true with the retained lands. This time the numbers are irregular depth of 81.44 and we're striking 78.86.
That is correct.
All right, excellent. That concludes that portion. So we are asking for a presentation from you, Ms. Gibson. So if you could proceed, that would be appreciated.
Okay, perfect. So I'll just start with perhaps the context of the neighborhood for those that aren't familiar with this area. So the neighborhood was constructed mostly in the 1950s and 1960s, and it's comprised of single family 1- and 2-story homes. What we're proposing, or I guess in recent years, we've seen an influx of new construction. So there's been lots that have been subdivided. There's been older homes that have been removed and then new homes that have been put in their place. So as you're going through this neighborhood, you see this juxtaposition of new homes and older homes, and it does create a really charming streetscape. It's got sidewalks on either side on V-mount. You have large mature trees, beautiful front lawns that are landscaped generally, and it is a really nice community. And so what we're proposing is to sever the lot at 12 V-mount and create 2 lots and build 2 new homes, which is what we're seeing in the fabric of this community, as this kind of variety and intensification. So that's what we're seeking to do. And we do have a variance that we've already received to change the frontage of the lots to 15.24 meters. I know there's been concerns by one neighbor that they've expressed that the new homes that they're seeing in this area aren't necessarily sympathetic to the architecture in the neighborhood, and we've tried to be sympathetic to that. So these proposed homes are 2 stories, which is what you see in the neighborhood. We've tried to take materials that are in keeping with the neighborhood. So we kind of have gray and tauped colored stone. And there's a lot of kind of gray and taupe colored homes in the area. We're keeping with within, we're actually slightly less than the maximum building height that's defined by zoning. And we have kind of similar setbacks. The setbacks meet the zoning requirements and they're similar to neighboring homes. So the front lawns will be kind of a similar depth to what's there. And then there's also been concerns expressed with regards to tree removal. And I know, that we do have to take down some trees. We have prepared a tree disclosure report. I believe there's 4 trees that we're taking down. And with those trees, we will be planting 11 trees. It's not shown in this rendering, but 2 of the trees will be in the front yard. So there'll be 1 tree in each yard. And then the remaining trees will be within the backyard. It's a really deep lot. And we spoke with the city's forestry services. And we have reason to believe that they'll thrive in the area that is available back there. I just kind of included everything just in case there was, a reason for discussion. But here you can see where we've, you can see at the top is the demolition where we have the existing home that's being removed. And then at the lower portion, we're showing what the proposed dwellings would look like. And I don't know that we need to walk through all of it, but you know, the elevations, and we've also included the plans.
Okay. Questions for Ms. Gibson? All right, no questions? All right, I just had one. Can you just tell me a little bit, Ms. Gibson, about the public consultation that you undertook for this application?
We did not take a public consultation.
You didn't do any, you didn't talk to the neighbors?
Oh, sorry, yeah, the owners did speak with the neighbors, and there was just the one neighbor that had expressed concern that I'm aware of.
Okay, and this is a lapsed application from a previous consent application that was identical, is that correct?
Yes, it's the exact same application.
Okay, all right. Any questions from other members? Ms. Gibson? Okay, in that case, I think I'm going to go to my speakers list. I may need some help, Ms. Byers. So I think I may have dropped that somewhere. Do we have anybody on our speakers list for number 10? Ms. Byers?
Yes, we did have a speaker, Madam Chair, but I no longer see them on the call.
All right. Okay, if that's the case, then let me just open it up to the public in general. Is there anyone in the audience who would like to speak to the committee on this application that's at 12 Viewmont Drive? Now's your chance. All you need to do is raise your hand, and the coordinators can bring you in. Okay, not seeing anybody come forward. So with that, then, members of the panel, Mr. White.
Thank you, Madam. Thank you, Madam Chair. Before we take the vote, I'd just like to reiterate my reasons for supporting the application for the minor variances previously. Under normal circumstances in this community, that reduction in lot width variance that was granted I would not be supporting that in light of the situation with respect to the zoning bylaw. However, in this case, it's a rather unique situation. The lot is located on Viewmont Drive, which is unlike most of the applications that we've been dealing with. It's a full urban cross section, functions as a local collector, as Ms. Gibson's indicated. There's sidewalks on both sides of the street. So the situation here, and given the very large lot area, the proposed lots, in fact, will, I think, exceed the bylaw requirements by maybe twice the size of the minimum requirements in the zone. So under those circumstances, I have no objection to the applications with respect to the minor variances that were granted, and similarly with respect to the consent that was dealt with previously, also had no concerns with that application, which are being duplicated here. So with those, just to make the committee aware of my position on this application, leave it there.
All right. Thank you, Mr. White. Okay, so we do have that on the record. Okay, with that then, let's go to a vote. Members, all those in favor? All right, okay. So I believe it's unanimously granted. So Ms. Gibson, you have looked at all the conditions. You're in support of all of them. All right, just wanted to make sure that you are you're fully aware of them. Okay, thanks so much.
Great, thank you. Good evening.
Good evening. All right, the last but not least application is 220 Woodruff Avenue, and I'm looking for Mr. Robinson. Mr. Robinson, good evening. Yes, we can see you and we can hear you. That's good. And okay, so I do need to read to you, I believe. Just always trying to make sure that I've got everything. Okay, So do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted first at the property to which the application applies for the prescribed number of days before the hearing, and that the sign was clearly visible and legible for the entirety of that time? Do you either swear or affirm that to be true?
I swear that to be true.
All right, we also have a slight amendment to undertake in your application. So it's registered plan 352 and not 544. Is that correct?
That is correct.
Okay. With that, we do want a presentation, Mr. Robinson.
Okay, thank you. So the application before you this evening at 220 Woodruff Avenue is for minor variances on this property and primary and secondary severance applications. Next page, please. Thank you. So on the left is the existing home that is on the property at 220 Woodruff. The property is on the west side of Woodruff between Carling Avenue and Richmond Road. To the right, and you'll see it in subsequent photos, there are a pair of semi-detached units with a single car garage and a single car driveway. That property has a building height of about 9 meters in height. Across the road from the property, there is a public school and a church. And to the south are, I believe it's a duplex building. And then further south, there's other single family homes and some semis. And then behind the property, there are also single family homes. Next page, please. So the photograph on the left is the property to the south. So you can see that it's a 2-story building. I believe its height is to the midpoint of the roof. It's about 8 meters high. They appear to have front yard parking, and they also have what looks like a driveway on the right-hand side. And then the photograph on the right is of the semi-detached units that are immediately to the north. And as you can see, they have a single car driveway and single car garage, slight peaked roofs, and their building height is about 8.9 meters. Next slide, please. So these two photographs show on the left-hand side the Woodruff Avenue Public School that is across the road from this property. And then to the north of that is the Woodruff United Church. And this, one of the variances that is being requested is to allow for a front-facing attached garage on this property. This area was brought into the streetscape character analysis boundaries after the original streetscape character analysis boundaries were initiated. It was added later, and typically 21 surrounding properties are surveyed or looked at in terms of whether they have a front-facing garage or carport, and then as well whether the front door faces the street. Because of the fact that across the road from us we don't have any residential properties, we could only look at the 11 properties that are on the west side of Woodruff, and of those, 5 have a front-facing attached garage and 6 do not. So it was a very close analysis, and we're asking for, that's one of the variances, is to be asking for a front-facing attached garage to the units. Next presentation slide, please. Thank you. So we've got some renderings of the property, looking at it from the southeast to northwest orientation. And then another one on the right-hand side, which is a front-facing rendering of the buildings. Next slide, please. This is the existing survey plan, shows where the unit, the house is now in relation to the adjacent properties. To the north, we have a setback of about 2.13 meters, so that's about 7 feet. And then to the south, the 4-unit building, that has a setback of just over 4 meters.
And the property itself has got a width of about, I think it's 15.24 or 50 feet, and a depth of 30.49 meters, so 100 feet. Next slide, please. So this is the site plan for the property, with the severance line down the middle with the horizontal red line. We've got garages for each one of them, a single car garage and a single car driveway that meets the bylaw requirements for the minimum width for a driveway. Front doors facing the street. We're asking for a variance on the ability to have a front-facing attached garage, and also a variance, and it's different variances for each lot for building height. The building height in the R4D zone for a semi-detached unit is 8 meters, and normally we'd be able to meet that. However, when you obtain the city's plan and profile drawings that show where the existing services are in the street, they are quite shallow coming in from the street, which as a result means that the starting height for this building would be higher than it would normally be if the services were lower down in the right-of-way itself. So that is the reason, by having fairly standard floor-to-ceiling heights and a peaked roof, and the building height is measured at the midpoint of the peaked roof. On the left-hand side, and it's all based on existing average grade. On the left-hand side of the property, the south side, which is 222 Woodruff, the building height to the midpoint of the roof is 8.53 meters. And on the north lot, which is the top of the drawing, it's slightly higher at 8.57 meters. They are the same building design. The reason for the difference in building height is because it's measured from existing average grade on each of the lots. And when you look at the existing grades from the survey plan, they have a different starting point for that. So the other thing about a garage is that there is a requirement, it's one of the conditions in here, that we need to dedicate a road widening of 3.9 meters so that the ultimate right-of-way for Woodruff is 26 meters, 13 meters on either side. So we're very limited as to where we can put parking, and we'd like to have a front-facing garage. It's fairly standard in semis like this. There is no street parking permitted on this side of Woodruff. It's and you can't get a permit for it. And that is one of the reasons for asking for a garage. And the streetscape character analysis showed that it was a very close summary. If we had been able to do 21 units, it would likely be a positive result for us. If we were to go and do 11 lots and go 7 one direction and 4 the other, rather than 6 and 5, we could have had a positive analysis that way. Next, please. This is the draft 4R plan that shows the units. As you can see, we have recessed the garages from the front face of the building, so they're not sticking out in front of the front face of the building. The red horizontal line that we've put on this draft 4R plan is the road widening that will be taken by the city as one of the conditions for this application. So, and that would occur up and down Woodruff if and when other properties redevelop. So it's the ability of the city to gain this land when a development application comes forward. Next, please. This is a cross-section drawing of the property. So the basement height, the floor to ceiling height is 8 feet. The main floor is 9 feet. And then the second floor height is 8 feet. Add those up plus the pitch of the roof, and you get to between 8.53 and 8.57 meters. I believe the height to the underside of the eaves is about 7.9 meters. And it's all based on the fact that the existing municipal services are quite shallow, which requires us to elevate the building somewhat. And I think there's just one more page in the presentation, and it lists the variances. So the first variances for both properties is to allow for a front-facing garage, as it does not reflect the dominant characteristic as determined by a streetscape analysis. As indicated, the streetscape score was 6 to 5 for no garage versus a garage, and only 11 out of the normal 21 lots could be reviewed. It was limited because of the fact that across the road, there's a school zone and a church, and they can't be included in the analysis. And then the second variance, it's a different variance for each lot, is that we our building height is in excess of the requirement for a semi in the R4D zone. It's due to roof pitch we would like to have, and as well the ground floor finished floor elevation can't be lowered because of the city services that are on Woodruff Avenue itself. Adjacent properties to the north are about 8.9 or 9 meters, and then the property to the south is about 8 meters in height. So these are not out of keeping with the adjacent properties. So that concludes the my presentation. This application was before the committee. I think it was in early January. I was not present. The project manager for the owners could not make it at the time, so we asked for a deferral. And at that time, there was an item identified on the site plan that the plans were showing a walkway going from the front door to the sidewalk along the road itself. And it was raised by the planner, Miss Cully, that based on the lot width, we can't have a walkway going from the front door to the sidewalk based on the lot width. So that has been removed, and we're here to answer any questions. Thank you.
All right, thank you, Mr. Robinson. Okay, questions from the committee. Mr. White, go ahead, please.
Thank you, Mr. Robinson. That comment, the last comment concerning the walkway, could I see the site plan? Because that doesn't make a lot of sense to me for access purposes. Can I have a look at the site plan, please?
I think I can offer an explanation, and we removed it. I believe that in some neighborhoods, people have been known to have a driveway like we're showing, and then they put a walkway beside it, and before you know it, the single car driveway becomes a double car driveway, and it's to prevent that. That's my understanding. There's oftentimes people put a walkway at the side of a driveway that then becomes, over time, it becomes a double driveway. And it's a clause in the bylaw that we are not allowed to have a walkway based on the lot width.
I'm not excited.
Correct.
Yeah, I'm not excited about that, but I guess we have to live with it. Thank you.
All right, any questions from the panel members? All right, so Mr. Robinson, I guess what I'd like to understand a little bit better is where are those services? If we can bring the site plan back up, because you're saying that you can't vary the height, or that you have to increase the height of the building because of the services, but from Woodruff. So I'm not really quite understanding how that's affecting your building height here, because that would be in the right of way if you're talking about the services.
Yeah, the services that are, I assume, are parallel with the front lot line, and that they come there. There's a stub or a spur that comes from there into the property, and it's the height that the service, the trunk services are in Woodruff itself. It's not, so it's where the connection point on the main services in Woodruff is higher than it normally would be on other streets.
Okay, and there's no engineering solution to that?
I don't believe so. And there's also certain percentages that you have to have of slopes.
Yeah, I understand that. So, all right. So you're saying the house has to be, and is that the case for all of the houses on that street?
Well, I don't believe that there has been, when I look up and down the street, there has not been a sort of new build within a few houses of this. Most of the houses on the street look like they're 60s and 70s and maybe 80s homes. And I don't know if they ran into an issue themselves at the time. I don't know what the maximum building height was at the time for the type of unit they were trying to build.
Okay, so, but it would seem that, all right. It just seems to me that if that's the case, then it should have been obvious to be able to show that throughout the street. But anyway, Mr. White, go ahead, please.
Madam Chair, I think I heard that the newer building next door to this one is also at a height that exceeds the bylaw requirement. It's probably the same reason to build a two-story, 2.5 story dwelling. You have to get the fall from the services at the house to the mains in the street, and you have to have a percentage fall. I completely understand the reasoning there.
Okay, I just wanted to confirm that it's in keeping with sort of what's been happening in the neighborhood anyway. So, okay, Ms. Willis, go ahead, please.
Just on the same issue. If this development at that particular zone, if it was stacked or a townhouse or a 3-unit dwelling, the maximum building height in the same area is 11 meters. So that's just different building form permits a higher dwelling. So I think the church across the street has a higher peak too. So I don't have a problem with either of these.
Okay, all right. I just wanted to understand that one a little bit better. Anything else? So I guess the only other comment, so and I want to give a chance to Ms. Cully to pipe in here, because Mr. Robinson, you've seen that the staff's report is not just has some concerns, they're objecting to your application. So Ms. Cully, I'd like to give you a chance to just outline for us briefly the reasons for your objection to the application.
Sorry, Madam Chair. Anytime that the streetscape character analysis is proposed to be varied, the city's position is to object to the application. So that is the primary reason for the objection. The building height in and of itself is something that staff believe could potentially be eliminated if the design was changed slightly. The secondary dwelling unit, that is the neighboring property that has been used as an example, was approved in 1983. So it predates the bylaw.
All right. Okay. Well, with that, then.
Just can I ask?
Yes, of course.
Ms. Cully, that makes me very curious, because no matter the extenuating circumstances that Mr. Robinson has discussed, that the other side of the street is a school and a church, and so they couldn't use the driveways, so they could only use the 11 instead of the 21 driveways. No matter what is presented to staff, the policy is to say no, as it pertains to front-facing driveways, or yeah.
For streetscape character analysis, through you, Madam Chair, one of the tests of the minor variance is if it meets the intent of the bylaw, and the bylaw clearly prohibits it, which is why we object.
Oh, so we'll see this every time if there's a close vote. Okay, interesting.
Okay, Mr. White.
Madam Chair, just a question to staff. Does this mean that should this application be approved, that the city will seriously consider an appeal?
Through you, Madam Chair, that's a good question, Member White. I have not looked into that specifically, so I cannot answer it at the time.
That would be really interesting. I think. Okay. Any other questions, comments? Mr. White? Okay, so I guess it's me that has, sorry. Okay, I don't have any members of the public on my list to speak, so I'm going to make just a general. So Mr. Robinson, you've raised your hand.
I had some questions about the conditions. Just wanted to make sure.
Public first. Let's hear from the public and we'll come back to the conditions, if that's okay.
Yep.
All right, so back to the members of the audience. I don't know how many people are still with us at 9:40 at night, but if you have an interest in this application, whether for or against, now's your chance to address the committee. You just need to raise your hand and the coordinators will bring you in. Okay, I'm not seeing any hands or anybody come forward. So with that, let's go to the conditions then, Mr. Robinson.
Okay, thank you. First one I want to talk about is number 5.
Hang on.
About a noise attenuation study.
Okay.
And I was hoping that could be modified to be a noise warning clause. The standard of the home is going to have, typically there's 2 items that get flagged in a noise attenuation study, and they are central air conditioning and a certain specification of windows. And my client has no problem with meeting those. It's just to do a study that has to be reviewed and then approved. We have to do another item in here is a joint use and maintenance agreement. So we're going to have legal agreements done. And I think that a noise attenuation, a noise warning clause could cover that off rather than having to do a study. So we'd like to have that modified. I've seen this happen many times with the committee before. So we're not in close proximity to Highway 417 or anything like that. So we're hoping that could be modified to be a noise warning clause registered on title. And then the other item we'd like to talk about is number 10, the tree planting. And on that scenario, we understand that, and it's listed as one of the comments, that a tree planting plan must be provided. That's fine. We understand that. We've had some discussions with Miss Young, and she's asking because of the fact there is one tree on the site, and it was basically at the rear of the new building area, so it can't be maintained. It's an existing tree, and it is already starting to see signs of decline. And the requirement says that they like to have 6 compensation trees, and I think a $400 per tree for 1-year deposit. That's fine. I'm wondering if there could be some flexibility on this because of the fact that, as you can see, there was a requirement for a 3.9 or almost 4-meter road widening. So you wouldn't want to put new trees in lands that are going to be taken by the city. So there isn't a lot of room in the front to have more than 1 tree on each lot in the front. And we can have some trees in the back to make up the 6, or, and this came up earlier tonight, I think on another item, to have the ability to plant 6 trees, but they don't all have to be on this property. And if they're right across the road, we've got a church and a school, there's Woodruff Park nearby. If something could be done between ourselves and Miss Young and her department to agree to plant 6 trees, but not all 6 need to be on this property.
Well, I think that's exactly what we heard from Ms. Young earlier today, is that, you know what? So to clear this condition, that's all you need to do. Talk to Ms. Young, figure out what you want to do. And I think what she's, look at what you can do with regards to the lots that are going to be created, but at the same time, where else could you put those? So Mr. Robinson, I think 10 needs to stay the way it is, but the flexibility is yours to figure that one out. And to go back to the noise attenuation, you're right that often it comes down to window treatment and air conditioning. So, although, you know, there's other ways to actually attenuate sound in a building, in a structure, and it always surprises me that we always kind of go to one thing, but in any event, just want to get some sense from you, Ms. Cully, then on this. So you're taking so these conditions are drafted directly coming out of the environmental noise control guidelines, right? I think.
Through you, Madam Chair, yes, that is correct. They are from the official plan. The engineers review the official plan, which refer to those.
Is there in those guidelines any examples of where there could be exceptions made, just so that we have some idea of whether something on Woodruff, because Woodruff is an arterial, I take it? So what does it say about that? Like, is there any wiggle room here to say that there would be an opportunity to lessen the requirement? That's all I'm exploring.
Through you, Madam Chair, I haven't read them in detail to be able to provide that kind of answer at this time.
All right. Okay. Right, those are my questions. Anybody else, Mr. White?
Madam Chair, I would have no problem with the suggestion, Mr. Robinson, with a warning clause registered on title in association with the agreement that's required for the joint use and maintenance agreement concept. And in light of the fact that it may be possible that the city is going to appeal this application in any case, I would suggest that we're not really risking a lot by suggesting a clause as opposed to the full-on study.
Okay, so let me throw something out there just for further consideration, though. So here we have a situation where we're specifically considering the widening of a road that's already an arterial and is already busy. So if anything, there'll be increased traffic in front of this house. So yes, if there was no change to the width of the road and all that, I guess I would be tempted to say, okay, let's go with just the warning clause. But in this case, we're looking at an increase to what's already a busy road in the future. And I think the study needs to take that into consideration. I don't think the study is going to look at the existing traffic counts today. I think it needs to forecast and figure out what that would be over time, and then decide what kind of mitigation measures in the construction would have to be implemented. So that's my only reservation to going with just a warning clause. Mr. White, go ahead.
Thank you, Madam Chair. I hear your argument. I haven't seen any evidence submitted by the city that would indicate any imminent widening of that roadway. And unless that's in the plans, I'd be reluctant to go as far as requiring a study on this site.
Okay.
My understanding is that
so Mr. Robinson, I'd just like to I want to find out from the other members. I want to get their thoughts on this. So Ms. Willis, what are your thoughts on that?
I think that warning clause and the what's the other requirement that forced air conditioning be included in the design of the house, which I'm sure it is, Mr. Robinson, is what it might come down to anyway. And I think that would eliminate the need for any study on this part of Woodruff Avenue, which may be widened at some point in the future, but who knows when.
Okay, all right, fair enough. Mr. Hindle, Ms. Markovich, any thoughts?
Yeah, I agree with Ms. Willis, like with the provision of AC and then the warning clause. I think that's probably sufficient. You know, it is a busier road, but we're not on, say, a full Carling and this is the quieter portion of Woodruff. So I'm happy to to roll with that.
All right. Okay. So Ms. Markovich, go ahead.
I was going to say, Madam Chair, I think it's a good point that you've raised about the widening. I was just wondering if there's any way we could get any kind of indication from the city about the prospects of that, or if that's something that they could speak to briefly today.
Okay, let's go.
For you, Madam Chair, I am unaware of any imminent plans for the road to be widened.
And yet it was retained as part of the OP review. Is that correct? Is that what I'm hearing?
Through you, Madam Chair, yes. It would have been in both official plans for it to be included as a condition.
Yeah, normally I would think that they would look at what the road widening conditions or requirements are as part of the OP review. I see Mr. White shaking his head, so he doesn't believe they do that. Oh, you're on mute. You're on mute, Mr. White. Sorry.
I've been through this a few times and examples of already four-lane roads where road widenings are taken, where there's some minor additions to, for example, shopping plazas and that sort of thing, where road widenings are taken because there's a certain standard that is applied with new construction that didn't exist with the original construction on four-lane roads. I mean, you're not going to widen a four-lane road through a residential community, for example, any more than it was widened in 1980. But the standards have changed for these roads if they're to be rebuilt, which isn't going to happen. So I mean, I think in this case, it makes absolute sense to simply cover the road widening scenario and the noise issue by way of the clause and the provisions with respect to construction.
All right, then I think I wanted to play devil's advocate, so we have this discussion, but with that said, then I think for number 5, we're going to go straight to, so I think Ms. Keller, remind me, but I think we just swapped this out for the condition that we would otherwise use that deals with the noise warning on title, right? Did we do that?
Through you, Madam Chair, if that's the way to proceed, that would just be a switch, is my understanding, yes.
Let's do that. Mr. Robinson, I take it that you're going to be in agreement with that?
Yes, that is fine.
All right, okay. Otherwise, the rest remain the way they are. Okay, ready for a vote. So on the consent application, all those in favor? All right, so for the record, the application is unanimously granted. And on the minor variances, all those in favor? All right, again, for the record, that application is unanimously granted. And I think that's it for our agenda this evening. So thank you, Mr. Robinson. I know it's late. Appreciate you hanging in there.
Thank you very much.
Thank you. Have a nice evening.
You too. Bye-bye. Good night.
Good night. So for the rest, then I need a motion to adjourn. Boy, that was quick. From Mr. White, and then seconded by Ms. Willis. And before we go, I'd like to thank everybody again. So to our planners, so Ms. Bauer, can we just say hello to you for a moment? We hadn't seen you before.